I don't think he's here to mention.
No mentioning today.
It's a conference mentioning the item number 187. That this matter was hard concluded by Lordship Division Makers by the standard. That the judgment could not be delivered. Terminated employee the professor without activity without to 2020 termination. 4 years have passed. Milord, I cannot withstand the pain of my stomach, Milord, for the last 4 years. It's a torture. I have been protected by the interim order. The government will not proceed with the further employment, Milord. Kindly see the humiliation, Milord. I, Milord, made a specific allegation of ragging, and I was made a victim, Milord.
Allegation of?
An allegation of ragging, Milord, and the allegation of ragging of a teacher, Milord. When, Milord, ultimately the National Human Rights Commission interference, Milord, at the dictation, Milord, the government has passed an order. Milord, if I correctly, Milord, grasped, Milord, the climate of the judge, Milord, the honorable judges, possibly my lord was there with the Tandon, Milord, and Milord Justice Tandon, and Milord, it was extensively hard. And Milord, the bench, Milord, possibly was persuaded that this termination was bad. Apparently, Milord, I cannot say with affirmation, Milord, that because it was in violation of the memos which protected, Milord, the employees of the government, Milord, that the 60 years of age, it will continue. And this is also in violation of these 5 constitutional bench order, Milord, that even if you are
within the intra-court appeal, it is hardly at 60 number. Why do you want to mention?
7, Milord,
Yes, from 128 intra-court appeals.
this is the appeal from the, Milord, the honorable tribunal.
Huh? 187. Oh, hearing matter.
Milord, I cannot, Milord, today, Milord, your lordships, Milord, I mentioned, Milord, this matter initially also. At that point of time, the business of this honorable court did not permit.
We are taking up hearing on a separate date, but nobody is appearing. We have called the list so many times.
Milord, this
Last 2 weeks we have called the list.
only one indulgence, Milord. If your lordship, Milord, since, Milord, I would not have disturbed your lordship. This matter was hard. The honorable division bench
That
was
we have
about
heard you, but then it's not that below.
Milord,
That
Milord,
much below on the list that it
Milord,
needs any.
I since it falls from your lordship, Milord, I cannot, Milord, I have an explanation to offer, Milord. Only indulgence I am seeking. Many a times this honorable court, Milord, directed the ballot to be posted on the head of to be mentioned. If I can satisfy, because Mr. Banerjee is also there, I can serve a notice. Milord, today it's a tremendous humiliation, Milord.
We have called this case twice in the
am
last
not
15 days.
Your lordship observation is a command. I am not disputing. I am only saying.
We are wondering why on the hearing of Old Matters Day nobody is appearing. We are calling the entire list, nobody is appearing.
I am not arguing, Milord. Milord, I want to resolve the issue, Milord. This matter was hard.
So it will be called. What is the day fixed for these matters? Thursday it will be called. It is hardly 50-60 cases below on the list. This Thursday or next Thursday it will be called. We are calling it. We have called the entire list twice.
Sorry.
Yes.
I will do it. I will do it.
On national part of 27, but in the page 3, at page 3, paragraph 7, the last letter. The petitioner's case was required to be considered afresh since the death of the petitioner's father, that would be petitioner's mother.
Oh, all right. To be mentioned.
May permit to mention one action in the list matter.
Give the inclusion, please.
Matter is unlocked.
What do you want? Give.
Inclusion.
Item number 1. I am taking to oblige your lordship for kind accommodation on that day when I was in me. Original application. Can click and take the first. I don't know. The get it accepted. Being obvious number. Sir, this is not the others. And finally, the order passed by the government tribunal, the CA number can show corresponding to CA number W 995, dismissing the application of the petitioner against the time of department of proceedings. Against the petitioner and sanction with the petitioner. Taking the decision order to issue the order of dismissal of the petitioner from the service, file of that will be real completion hospital. Now there is going to pension. A petition for one of the four. In the day of the petitioner, Central Court, an application for substitution and for amendment of the substitute of the petition being domiciled and so is filed by the clerk and certificate from the state. These are different.
We are not 28/6/2004.
And so, in the draft of the petition of order to the presence of the court, authority procedure for submission native or etc. There was substitution application to be taken from. In my law, कीजिए नोटिस कर दिया कौन जाए
Who is for the respondent?
Can number 3 of A for subdivision not more fund has got C, but it's different for the this cancel 126. I stated the reason because I was not communicated. But I'm advocate on the record as that time.
What is pending?
Pending the original that is tribunal application under the I had that dismissal of that particular. We had been tribunal because of the dismissal of the petitioner.
What is pending after this court's order of 28/6/2004? What is pending?
Meaning minor,
Have you seen order of 28/6/2004?
yes.
What is the order?
But see,
What is the order?
see, that is what I wrote 96. The main distinction.
28/6/2004, this court has passed an order. Where is that order? Have you read that order? Again, we are asking you, this court has passed an order on 28/6/2004. After that order, what is pending? Sir, please try to answer what we are asking you. 28/6/2004, the coordinate bench dealing with this case has passed an order. What is pending after that order? Is there any affidavit, supplementary affidavit filed saying that anything is pending, or for what you want restoration?
Opposition reply direction হয়েছিল কি opposition
মানে substitution application order for the
থেকে কোনো direction
against the government and file application for restoration.
How many times you will say that? And how many times we'll repeat our question? Again, we are asking you 28/6/2004, this court passed an order. Where is that order? You don't even know it and you are not answering the court's question. What is this? Unnecessarily a restoration. The court has directed for paying everything. Whether it has been paid or not, tell us. Otherwise, for what purpose a restoration is to be?
I have understood, my lord.
28/6/2004. You check up the order. You look at this file. As paid, not today. You examine it. You ask your client whether anything is pending or not.
I have understood, your lord, but
No order, not today.
I don't.
Not today.
For which, or,
Please show him the order. You show him the order. 28/6/2000.
and then for 10 days, I,
फाइल पे देखेंगे
I'm there, sir.
देखिए आपने ये देखो।
I'm there.
Item number 2,
Well,
Sorry, no, that person can be
And two, I appeared for the appellant. This is my application for review of your lordship's order.
Yes.
But on the last occasion, my lord, when the matter was taken up for hearing, my lord was observed that you have to satisfy your lordship, my lord, that there is scope under order section order 47, my lord, the scope of review is there, and under the guise of my lord review, you are not asking your lordship, my lord, to hear the appeal on merits again. This is the 2 point, my lord, fell for from your lordship, my lord, to satisfy. And first, I want to submit it to your lordship, my lord. Order 47 before your lordship. What is the scope of order 47?
We can read, or it is well known to all of us. There are only
May I
basic
read that?
two grounds.
Yeah.
Third is any other sufficient clause.
Sufficient clause and misconception.
That is also not left to interpretation. It has to be read in the same context. A jusdem generis. Yes.
And my lord, to that, my lord, I am relying, my lord, the decision of the Honorable Supreme Court, my lord, 2005 4 SCC 741.
No. Before we go to judgment, there are two things. There is no vital evidence or material which has been omitted in spite of due diligence. It is not falling under that
Not
category.
that, my lord.
There is no error apparent on the face of
No.
thereof. All right. Then what judgment
My
you
lord,
want
the
to?
sufficient reasons, my lord, and the subsequent.
All right. So
facts.
which judgment? Let us see.
Number 4.
Dear lordship. This is my 2005-4 SCC, my lord, page 741. And my lord, the relevant paragraphs are, my lord, paragraph 88, 89, and 90. Paragraph 88, we are furthermore of the opinion that jurisdiction of the High Court in entertaining a review application cannot be said to be expressly bad in law. Section 114 of the Code empowers a court to review its order if the conditions precedent laid down therein are satisfied. The substantive provisions of law does not prescribe any limitation on the power of the court except those which are expressly provided in section 114 of the code in terms thereof. It is empowered to make such order as it thinks fit. 89, Order 47, Rule 1 of the code provides for filing for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence or when there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. And 90, my lord, thus a mistake on the part of the court which would include a mistake in the nature of undertaking may also call for a review of an order. An application for review is also maintainable if there exist sufficient reasons thereof. Therefore, what would constitute sufficient reason would depend on the facts and circumstances of the case. The word sufficient reason in Order 47, Rule 1 of the Code are wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine actus curia remainder government. This is the, my lord, the judgment that I am relying on. The issue decided in the judgment. And I am also relying on a section Order 20, Rule 5. Order 20, Rule. Go to
Yes.
But I am also relying, my lord, another judgment, 2016, 13 SCC, page, my lord, 135. And the judge said to them, but here, my lord, the lordship kindly peruse the footnote. Code of Civil Procedure 1908, Order 47, Rule 1, Section 114 of the and Order 47, Rule 1, Supreme Court Rules. Review. Error apparent on the face of record, necessity of effecting rectification held. Once error is found in order, judgment which is apparent on the face of the record, same must be corrected. Court, while adopting such course, is guided by doctrine of ex dividio justitiae as well as fundamental principles of administration of justice, that no one should be suffer because of the court's mistake.
But you said at the very outset that it's not a question of error apparent on the face of the record. Therefore, why this judgment?
The other portions, sufficient reason.
Sufficient reason you are relying upon this. This is on error apparent on the face of the record. You said your admitted position is that it is not a case of.
The sufficient reason, I can straight away go to that one. Another
No.
judgment.
Anyway, so how this judgment? What is the fact of this judgment that you are some other judgment?
Yeah, another judgment.
Yes, give it.
This is my 2019 3 SCC
Yes.
687. Article 137 review petition, factual error committed by Supreme Court while dismissing the appeal which altered outcome of the case, hence the said order is recalled. But in our case, but while your lordship, my lord, dismissed the appeal, my lord has observed that we have not advanced any argument on merits.
Yes.
And in support of this contention, my lord, Order 20 Rule 5 of Seal Procedure Code, my lord, may I hand up to you, my lord. I have one CPC only. Judge Sahib, I have CPC.
We have, don't worry.
Order 5, Rule 20. my lord.
So that,
Order 20
that
Rule
is, you are trying to highlight infirmity in the judgment, that all issues have not been answered.
Yes, my
So if not answered, it is within the scope of review. That is what you are saying. Very well.
lord. Your lordship, my lord, 2 point. My lord, I tell your lordship the facts now, my lord, in my own way, my lord.
Sir,
What-
why should we look into the facts? We have seen what ground you are
My
urging.
lord, only to
You are saying that the judgment is bad because all issues have not been decided.
my lord has
Now,
not-
whether this is an issue which can be raised by way of a review application, that is the only issue.
that is my
For
lord.
that, you have shown 3 judgments.
My lord, because my lord, had your lordship called me to argue, my lord,
We
on
don't.
merits, my lord,
We
the situation would have altered.
We didn't.
But that is the judgment of the ratio.
All right, that we have seen.
That the situation would have been altered. That is
Yes.
why I am just, my lord, reminding your lordship.
What decision you must have seen the facts when you are relying on this
That is
judgment.
that.
Admitted position in that case was that decree was satisfied.
Here,
That was an admitted position
this is
which the court omitted to consider.
this is a
Is
case,
this-
my lord, the admitted
Nothing.
position, my lord, that
There is, we don't know.
my lord, it is my
There
duty,
is
my
no
lord,
admitted position.
my lord,
What are they admitting? Because you say it will not become admitted.
my lord,
There both parties said. They also said that yes, the decretal amount was deposited.
my lord,
In appeal also, we have lost. The
my lord,
the court is not left
my lord,
with
the
any. That
sufficient
is an error apparent on the face of the record.
my lord, the sufficient reason, my lord, the court has not asked my lord, asked to call to argue on merits. My lord, order 20 Rule 5 says court to my lord, decide all issue.
Decide all issue. Yes, it has not decided. We are
Yes.
not saying the order is correct.
But if your lordship, my lord, holds that is, my lord,
Why should we hold in review? We are not sitting in appeal.
your
We
lordship,
cannot look into
Well,
that in
well,
review.
it can hold both way. Either your lordship allow our review application or dismiss our review application holding.
See, one of the judgments you are relying upon is against an order admitting a review. That is nothing. The other, it is an admitted fact. The third also, we don't know how it is covering your
My lord,
case.
your lordship kindly
So these
consider
judgments, whether they
that
help you.
court is bound to decide all issue raised before the court. But if that
Are
is
we
not,
sitting in appeal over that judgment that we will say, yes, this has not been decided? That yes, this has not been
My lord,
decided. There's an error.
if my lord, according to my submission, if my lord accept our submission, my lord can call us, my lord, for
Yes, and
argument.
re-argue the matter to decide that issue.
My
That
lord,
is what we are
because
saying.
that has not been decided by your lordship.
All right.
That is my submission before your lordship. And if
Yes.
your lordship accept, my lord, that apart, my lord, the BCCI matter, even the court has decided subsequent fact.
Sir, in
my lord,
BCCI matter, the only issue in the review what was pending before the appellate court is whether it should have been admitted. Nothing more.
I think
Court said it is only an order of admission. Why should we look
if
into
your
it?
lordship, my lord, what we rely, my lord, the principle decided in the
That we have seen 88, 89, 90 we have seen. Whether it applies to the facts.
my principle design. In that case also, my lord, subsequent event. Well, now my lord has held that the suit is very much maintainable. Now, in view of the latest judgment of the Supreme Court, my lord, your lordship has held that an award of the Lok Adalat, my lord, an award of the Lok Adalat can be challenged only by third party or non-signatories. But
Review cannot sit as a appellate court. You decide the matter.
you,
You were party to the. This is with you. No.
and your lordship has, while decided our appeal, my lord, has specifically held that the award can be challenged by a third party and non-signatories to the settlement by filing a suit. My lord, that also, but our argument was advanced that that cannot be. And here, my lord, the person who filed the subsequent partition suit, they are the heirs, they are not the third parties. So, my lord, that point does not cover. But that apart, your lordship kindly peruse, my lord, the latest judgment of the Supreme Court on this.
We are not going to rehear the matter, sir. Be very clear. We are not going to rehear the matter.
And only your lordship kindly consider
Sorry.
and decide our matter. May I please?
We will not touch those points. We will say that these issues cannot be raised in a review. We will not touch this.
If your lordship, only one.
How can we?
It
We
is-
start doing this, then every case, then a review will sit as an appellate court. Wonderful.
Your lordship, my lord, kindly consider, my lord, had your lordship called
Sir, consider what settled law is there. What is there left to consider? Neither CPC permits nor the law is interpreted through judgment.
according to
And
my
we will
judgment,
sit and appeal over our own judgment.
this is not
And we'll redecide.
this is not sitting on appeal, my
It
respectful
is
sir.
precisely sitting in appeal, nothing less, nothing more.
My lord, this is my respectful submission, my
You
lord.
may submit. You
It
can
is
submit.
My lord, your lordship kindly consider and pass, my lord. But I am giving another copy, my lord, just my lord. Only paragraph 13.
Yes. Give it. Give another copy.
My lord, I am giving, my lord, just my handing over. That is my extra copy is not here. My lord, may I hand? Read it out. The reliance placed by the High Court on section 22 capital E4 of the Legal Services Act.
Who is for? You are for the respondent. Yes.
My lord, the reliance placed by the High Court on section 22E4 of the LSA Act is also misplaced. The stipulation that an award shall not be called in question in any original suit shall not be called in question in any original suit application or execution proceeding is a prohibitory clause which reinforces the bar against the collateral civil challenges to a Lok Adalat award. It does not create a separate class of civil remedies in favor of persons who were not parties before the Lok Adalat, nor does it enlarge the jurisdiction of the executing court to set aside or invalidate such an award at the instance of a third party. The statutory structure is the same whether the aggrieved person is a party to the award or is a third party who claims to be affected by it. In either case, if the validity of the award is to be examined at all, it has to be tested in a writ proceedings before the High Court and not by expanding the scope of execution or by encouraging independent civil suit. And this is subsequent judgment. Though we relied on that, in that case, my lord, that is why I just want to keep the little background of this case. What happened? My lord, 52 years back, a LOA was executed. But on the basis of that, my lord, the beneficiaries filed a partition suit. That partition suit ended with a, my lord, award passed by Lok Adalat in 2011. In 2019, my lord, one of the beneficiaries, my lord, has filed a suit for partition and injunction in respect of the self-same property, declaring that the award is bad and not binding upon him and invalid. But this is the basic. My lord, the Supreme Court has latest judgment also said that that suit is not at all maintainable even at the instance of the third parties.
So we should set aside the judgment as if we are sitting in appeal.
But your lordship kindly, my lord,
This is the argument that you are advancing is an argument to be made before the appellate court, not in a review. We are not saying that we will certify it is correct, we will certify or we will set aside in a review.
it is our duty, my lord, to draw your lordship's attention. My lord, it is your lordship to pass.
Sir, it is your duty, but in an appropriate jurisdiction. So jurisdiction, ultimately, you are an officer of the court.
That is why, my lord,
For jurisdiction, thereafter you are,
that is why.
then your
My
duty
lord,
comes to point out things.
My respectful
For
submission,
jurisdiction, you are an officer of the court.
my respectful submission, madam, may I place that part of the judgment where your lordship has said, my lord,
We are not sitting in appeal, sir. We are not sitting in appeal. We are not going to certify that the judgment is correct, or we are not going to say that judgment is wrong. Review is to be resorted for the issues which are falling within the jurisdiction of a review court, order 47 rule 1. We have seen the judgments that you have given.
My lord, to my responsible
If we
submission,
start entering into this kind of thing every day, there will be no finality to any judgment. It will keep roaming within the same jurisdiction.
I think that is not, my lord, in the
Precisely, you are saying that the judgment is wrong. This is your submission.
no, I am not.
All issues have not been decided. There was a compromise. That compromise should have prevailed. This is what you are saying.
At your lordships, after.
And we have decided the compromise cannot prevail because that was only maybe admitted, but it did not form part of the
Had your
LOA.
lordship, my lord, according to
So
my
you want
submission,
us to re-examine the issue.
and had your lordship called us for argument on merits after holding, but my lord, what is your lordship is doing every day, my lord?
Then maybe
Your lordship is holding, my lord, when we move a matter before your lordship, the other side takes a point that this is not maintainable on the face of it. Then, my lord, your lordship ask us to satisfy your lordship that this is maintainable. Once it is maintainable, then your lordship goes into the merits of the case. Now, this is a case, my lord has held that the suit is maintainable. Once your lordships hold that the suit is maintainable, my lord, in that event, my lord, your lordship would have called us, my lord, to argue on merits of the appeal, my lord. That then we could have got the chance. Well, the situation would have been altered by that.
that we have understood. That judgment you are relying upon. In every case, if in review we take a contrary view, the situation will be altered.
Why, my lord,
That means we will hear it like an appeal.
that is why, my lord,
Situation will be altered in every case. It's not unique.
that is why in every case review are not filed when the.
But if we do this in every case, it will be filed. It will start being filed every day. It will become a routine.
Well, your lordship can clarify or modify that order, my lord, that this was not done, my lord.
That's all. Yes.
Principles of review are well settled, my lord. I know just anything. But with regard to the subsequent judgment, my lord, there is another judgment. I'm not ready with that. Which says on Supreme Court judgment, which says that the review cannot be entertained on the basis of a subsequent judgment on the point. If required, I can come with it, my lord. Just now, my lord, I searched. I found even in 2025, there's a judgment which says that the review cannot be maintainable on the ground that there has been a subsequent judgment on the issue,
Yes.
holding contrary to or otherwise to what has been decided in the impugned.
Come with the judgment. Come with the copy. The learned advocate for the respondent submits that he will be.
I am for the petitioner, madam.
For filing
Affidavit in opposition, madam.
the learned AGP seeks extension of time for filing affidavit.
Item number 5.
No, PPAN. Oh.
Well, I'm appearing for the applicant, senior advocate Sushanta Pal is appearing. His legs in the another court. I'm paying for very short pass over my.
এটা তো এক সপ্তাহ পর আসবে, ম্যাটারটা এক সপ্তাহ পর আসবে, 9 তারিখে।
May I place my
Just
Any document showing the age of the wife of deceased?
Wife of the deceased, my lord, Lord, kindly come. Report, my lord.
Page
Page 46, my lord.
46.
My lord. Belated request clause, my lord. 52 years.
No, this is a finding. On what basis? Where is the material?
And
What was her date of birth? How you are saying more than 52 years? In any representation or any application, they have stated this fact.
regarding widow, my lord, no document, my lord.
But this is not disputed. Last day we have recorded that it is not in dispute. But from where this date is? And at what was the age of the father at the time of his demise?
See,
How many years of service?
37 years.
Huh?
37 years, my lord.
37 years. So he was 37 years and his wife was 52 years.
No, my lord. Served, my lord. Total length of service 37 years, my lord.
Oh.
Page 40, my lord. Perform of service.
But at that time, father of the petitioner died 58 years old.
58.
58 years old.
In 2009. He was 52 years. And when the children attained majority?
30th August 2013.
Much after 2 years.
Plain paper application, my lord, I have something to say, my lord. Plain paper application, my lord. Or you kindly come order of the tribunal, my lord, page 61, my lord.
Yes.
Says, my lord, a supplementary application has been filed having a copy of the plain paper application submitted by the applicant before the respondent authorities on 26th March 2014. It appears from the office seal given on the body of the application such application was received. However, this is subject to verification of the original records of the office of the respondent, my lord. Also, I am placing that application, my lord, page 26. But you kindly come page 26, my lord. This application, my lord, is tribunal routed, my lord. Kindly come to the date of the application, my lord. Page 26.
Yes.
English 26 May 2009 maybe. It was tampered, my lord.
No, no. When it was filed, 26 March. When it was filed? 26
Lordship,
March.
on the top, my lord, seal is there, my lord. Seal is not legible, my lord.
Oh, that's that one.
Seal also not legible. Lordship, kindly come. After this, my lord, 28 page, my lord. Page 28. Petitioner has says, my lord, paragraph, second paragraph, my lord, and that since 2009, my father leaving behind myself and my mother, Chandana Roy, and my only sister, Tania Roy. Due to our financial problem, I applied for government job under compassionate ground, but that time my age had below 18 years. This application made on 2017.
No, another aspect is
So reference of that application, my lord. That application may be subsequently, I do not know, my lord.
that is they are claiming it to be of which date?
They are claiming in the top, my lord. Top seal, my lord.
26/3/14.
Lordship. The seal is not legible and date also, my lord.
No, what we are asking you is, even if this had been filed on 26/3/14
Lordship.
on a proper format, then who would be eligible? Let us for a minute presume that it was filed on format as it is required to be filed.
Lordship.
What right will arise from this?
51 EMP says, my lord, within 6 months, thereafter,
So that is the issue, whether it is filed on format or not, or
thereafter 2 years, my lord.
it hardly matters.
26 says, hardly 2 years. And in special cases, 5 years, my lord. And they have filed after 7 years.
No, but she says that she has filed in 2009 also.
That is plain paper, my lord. And 278 says, my lord, 2015, my lord.
Where is that? Where is the 2009 application?
Page
2009, my lord.
23. Page 23.
20?
Page 23, my lord. For his son.
So therefore, again we will have to answer the same issue. If 2/4/2009 this application was filed on format, what would be the result?
Okay, since EMP clearly says has to be, my lord, in prescribed form, my lord.
No, we are saying even if it was filed in the form, what will happen?
Since the child is minor, nothing can be done.
Therefore, that's hardly relevant whether it is filed on a plain paper or on a proper form. That is not relevant.
Sure.
The point is if they are eligible and there is a lapse in presenting the proper form and it is on plain paper, then only this issue will become relevant. Admitted position is none of them are eligible. Mother is 52 years, others are minor who will attain majority much later.
Much later.
So therefore, a very unfortunate circumstance,
Very
but
unfortunate.
because 5 years, the time 5 years has been introduced for the first time by 26 EMP. That is of 2016.
16,
That is much later.
much later,
And at this time it was 2 years.
2 years. Initially 6 months, thereafter 2 years.
In 13 it became 2 years.
In 16, my lord. 13 was 6 months. Thereafter 26 says 2 years.
No, sir.
What's the may I place, my lord? Page 38, my lord. 26 says
26 says
timeline
2 years. Page
Page 38, my lord. 10A, my lord. Timelines. If the family of the deceased or the employee retired on being permanently incapacitated in need of financial assistance and the same is absolutely necessary to support the family, application for employment is to be submitted within 2 years, my lord, from the date.
So in 13 it was 6 months. Yes, tell us how it can be considered. We are, for the moment, we are not concerned whether it was on format or plain paper. Let us take it that it is on format. How it can be considered?
And after that, page 54, the authority says that no vacancy of the peasant. That's rejected.
Again, we are telling you, forget everything. We are presuming that it is on format. Everything is all right. There is a vacancy. How it can be allowed? You tell us. All the points that you are raising may only entitle you to re-agitate the matter. We want the petitioner to know what is the fate. So tell us whether there is any scope. That is why we are asking you. It says 2 years. Admittedly, even within 2 years, 3 years, both of you were not going to attain majority. Admittedly, at the time of death, your mother was beyond the age of appointment. She could have asked for relaxation. She did not do that. Now she is also not eligible. So therefore, what can be done? There was a scope for in this unusual circumstance. If there is the circumstance was so compelling, you could have asked for waiver of the maximum age criteria. Then the competent authority could have decided. You have not done that also. So your anxiety was to somehow get a job for your children. Then in this circumstance, how it can be? That's what we are asking you. There is no scope. There appears to be no scope from plain reading of the provisions. And he was working as?
Constable.
Constable.
Why there is an FIR? What happened?
Accident death, my lord.
Accident did
While on duty.
on duty.
So did the family get anything else? Ex gratia or something like that?
What's stated, my lord, in the report, 3 months committee report says, my lord, 2 lakhs, 1,25,000,
Where is which page?
page 46, my lord. Top.
No, no, no. Two lakhs on compassionate ground.
Very
We are giving only 2 lakhs for a constable who has lost his life while on duty. Where is the rule governing grant of this amount? This is under which provision 2 lakh has been granted? Is there any guiding principles? Length of service, remaining length of service, anything?
I have to take instruction, my lord.
All right, you come with that, then we'll decide the matter. You come with that, then we'll decide the matter. Heard the learned advocates representing the parties.
That plain paper application will be,
Sir, we are saying if we take it that it is on pro forma, forget about.
yes.
What will happen? Wife is 52, both children are much below majority. What will happen? Forget about plain paper and pro forma. If we take it that it is on pro forma, what can be done?
Subsequently, my lord, in the, as because, my lord, they are not rejected my claim for compassionate appointment, and all undisposed, my lord, application will be considered in the light of 2016.
Sir, undisposed application will not breathe life into something which never came into existence. None of you were eligible at any point of time. Undisposed does not mean any matter which was not even worth consideration. It means that which was pending consideration. Therefore, we are saying even if you had applied on pro forma, that consider my son or daughter's application,
Part of date is 5 years.
even if we take it 5 years,
Then
2014, yes,
we have applied it, but they have taken into consideration
you have attained majority when?
2013 August.
Cannot be. That cannot be. That
Within
cannot.
5 years,
That cannot have a retrospective effect. That 5 years cannot have a retrospective effect.
But the Grievance Committee recommended my name. I sat examination, and there, my lord, I overcome all the hurdles, my lord.
Maybe they are not saying that you have not done. That is not in dispute. The point is, person who was not eligible, how he can become eligible?
Because condition is 5 years, my lord, within 5 years.
No, it is not. That 5 years is of in 2016. Demise has taken place in 2009. Cannot stretch so far. There has to be some limit. We have seen the circumstances are very unfortunate, but what
And, my
can
lord,
be done?
penury is still there, my lord. That is the Grievance Committee.
See, with this penury aspect, when you say, then we are prompted to again say, you were not here when we were asking him. If you were truly in penury, you would have approached the authorities for relaxing the maximum age criteria. You never did that. Immediately you say, appoint my son when he becomes eligible after 4 years, 5 years. What penury? This demonstrates any penury. Penury desperation would have been, please increase the maximum age criteria, how we can survive. I need an appointment right now. You never say that. You say when he becomes eligible, you give him the job after 4 years, 5 years. Wonderful. What penury?
Authority has, my lord, accepted, and the, my lord, DIG.
You are again and again submitting that. That we are saying that's not in dispute. You pass the test, the committee recommended. Is that all that is required? Or basic eligibility is required? You should have, your conduct does not show that penury, and it doesn't. So shows more a consideration that my son or daughter should be appointed. So the law is very clear and it cannot be stretched so much now. You have the decision, recent decision you have seen. Devrata Tiwari's judgment. You must have seen what the apex court has now said. Says strictly in accordance with the rule. The rule does not permit. So we are asking them why they have paid only 2 lakhs, because we saw a fact that he has died while on duty. So why they have paid only 2 lakhs compensation? Let us see what they say.
Instead of 16, now 17.
Huh?
Actually, that's some difficulty. 17.
All right, 17.
17. 17. 17.
Item number 6.
May I please your lordship? I am for the petitioner, my lord. Last occasion, lordship was pleased to direct the state respondent to produce the relevant statute for the appointment of the petitioner, my lord.
Yes, where is the provision for appointment of civil defense volunteer?
Now we have not received it. One big time, then independent.
Yes, for complying with the last order, the learned AGP submits that he requires one more.
My lord, 6 to 10 million similar meter, I beg. Same order.
Yes, we remember there are 4 cases.
5 cases, my lord.
5 cases.
9 are sitting, 10 are.
So you will file it, then it will govern all the cases.
One order, that will suffice.
আপনি সপ্তাহগুলোতে আছেন স্যার 6 to 10 আপনি আছেন
হ্যাঁ
দেখে নিন
ওই পরিত্য দেখুন নিচেটা আমার লেখা
এটা
হ্যাঁ yes.
Item number 11.
নয় ইয়ে ফেব্রুয়ারি কারো
এটা চলছে
You are appearing for the state. In 11, none appears for the red petitioner. This
Item number 12.
copy has been served. An affidavit in opposition is filed.
Thirteen.
স্যার 11 12 দুটোতে আপনি ছিলেন
Item number 14,
14 मेला IPF
There is a decision of this court in this regard.
That I have brought the orders. That Arjun Kumar Soren.
You have the judgment.
I have brought the judgment. But three judgments I have collected.
No, I have decided this issue.
Yes, yes, sir. But kindly have a look at the judgment of your Lordship. Arjun Kumar Soren. In my case also, my mother was eligible for appointment, but she could not qualify because of her ill health. Same here. He forwarded my name. I was interviewed. I was medically examined. After that, they have rejected my case. One more judgment of the Honorable Supreme Court, my lord, that I have handed over to your lordship.
What have you handed over?
One judgment of the Honorable Supreme Court in case of Malay Nanda Sethi versus State of Odisha, where my lord, the Supreme Court has held on May 20th, 2022. That my lord, if the respondents are at fault, grant appointment for a long period, but the petitioner cannot be punished. Yes, my case has not been rejected on that ground.
Where?
Affidavit.
It is the same document. It is the same document at both places.
The criteria for immediate financial risks of the family have not been, and this has been said in page 43 of the Government Order 9 September 2019.
What is the inquiry report? 3-man inquiry committee. The 3-man inquiry committee has held page 37. In view of the fact mentioned, it is unanimously recommended that Tonoy Mondol, son of Swanso, may be enrolled to the post of Constable of Police on compassionate ground. It is also certified that the proposal of Tonoy Mondol, son of Swanso, for compassionate appointment for the post of constable has duly been re-examined in the light of the comprehensive policy for compassionate appointment 2013 and found satisfactory in all respect towards recommending appointment for the post of constable. Page 37, it is their report, 3-man committee. Yes, and Justice Horish Tender's judgment is on that. If the recommending committee has recommended something,
then why is that being sent to the government?
I have annexed that judgment of Justice Tendon. Page 91. Justice Tendon and Justice Vishas. Same thing happened there. The 3-man committee recommended my name, but the department has rejected. Page 96, the observation of the court. We do not further got it. This is Tender's judgment. Page 96. As indicated above.
So is it your submission that three-man committee recommendation is binding on the government?
Yes, but this has been held to be good by Justice Tendon at page 96. That if the kindly have a look to what the observation of the Honorable Court, as indicated above, the committee found the family needs appointment on compassionate ground to the petitioner and may be considered in this regard. The moment eligibility criteria incorporated under paragraph 6 of the said scheme is found to have been fulfilled or satisfied by the inquiry committee, and in fact recommendation was made in this regard, unless there is incriminating materials found in course of hearing by the said authority, and if there is no
By which authority? Incriminating material found by which authority?
by the state.
So therefore, when you say it is binding, then where is the scope for the state to look into anything?
Yes, Namalat, that's why Malat, the same thing happened here.
You are making a submission as if once the three-man committee says okay, then nothing will come in between.
Malat, yes.
Can it be taken as a proposition?
Malat, that was same thing happened here also. But kindly give me 1 minute time. Malat, the three-man committee here Malat, recommended my name.
Sir,
Malat,
the submission that you advanced is that three-man committee, once it says yes, there is no going back.
yes, that is my submission.
All right.
And that has been affirmed by the High Court in the division bench.
By which division bench?
By this division.
No, we don't find that anyway. You may say so.
But kindly, may I complete my...
We have read page 96.
Yeah, for my...
Yes, you may. The problem is you don't want to read 95 before 96.
Yes,
I'm that is why you are making submission.
Well, I'm reading
There are two aspects in that case, whether unmarried daughter was to be allowed or not.
Yes, yes.
The court found that unmarried daughter was to be allowed.
Yes.
And then said that since this hurdle is over and the three-man committee has found it has to be given. So if what you are submitting is taken, then even if the three-man committee says for a 5-year-old person, then it has to be given.
No.
Can it be?
But
again and again we are asking you, you are saying yes, it is binding. Once the three-man committee says it has to this. That's not the court's finding. The court was considering two things. The first thing was whether unmarried daughter will have or not. The court found that the three-judge special bench has already held that she is entitled. Matter taken up to the Supreme Court. Then the court said three-man committee has recommended you give it. Not that three-man committee's recommendation is binding what you are submitting. Cannot be. That will be turning the scheme upside down.
No.
The appointing authority's secretary is bound by the three-man committee report. What a submission you are submitting. You are saying, yes, that is my submission. Therefore, 3 times we asked you. Cannot be, sir. It cannot make eligible he or she who is ineligible under the scheme. It will certify the destitute whether those criteria are fulfilled or not. That is not binding that once it said it should be given, it has to be given. There is nothing that can come in between. That cannot be. And that's not the judgment. You please read from page 95.
But I am. Because before the special bench also, but I appeared for the petitioner.
We don't know. We will go by the judgment. What all arguments? We don't know.
In this judgment also, but I appeared for the petitioner.
But this judgment is very clear. It does not say that it is binding. Nowhere. It cannot say it is binding. It cannot say it is binding. It cannot say it is binding.
But I am not in quarrel of the honorable judgment. May I?
Every day you are saying this as if you are arguing with us. Why do you make such a submission, sir?
No.
That I am not in quarrel with any judge. We are here to quarrel with you.
No. But may I?
Why you have this kind of perception or obsession in your mind? We don't know. We ask you a query. You say I am not in quarrel with any judge. Wonderful submission.
May I place it in my own?
I don't know with what mindset you are making submission.
But I have
think
no
we are
such mindset.
quarreling with you.
No.
We are here to quarrel with you. What a word to use in a court proceeding for the bench.
But may I only place in my humble way.
What of submission you are making? I'm not here to quarrel with the bench. Why do you make such a submission?
But kindly, do not go into that. But kindly,
We are not here to quarrel with you. We ask you a query. That means we are quarreling. Thrice we asked you whether it is your submission. Thrice you said yes, it is binding. So we are saying why we don't think it is binding. So then if we are not supposed to say anything, the moment we say anything, it is a quarrel with the lawyer.
No, not at all.
What kind of submission you are making?
Not at all. But may I place it in my own?
Unfortunate submission.
But
that
kindly
I'm
do
not
not
in
take it
quarrel.
in that fashion, but I never intended to say.
This is not the way.
No, but I always, but I am very humble to the honorable court, but your lordship has found me.
You are bound to be emphatic to your client's case. Why not? You should be. We don't discourage, but we interact. We want things to come out.
Absolutely.
We want things to come out. The moment we'll ask anything, you will say, I'm not in quarrel with a bench.
No.
Honorable
But
submission.
your lordship kindly do not misunderstand me. But I did not say in that fashion.
You say whatever you want. We'll hear quietly and then we'll pass the order. Make your submission. It's not a laughing matter. Don't trivialize this. Don't try to trivialize this.
No.
We don't appreciate this.
Kindly do not take it in that fashion. But I never said it in that fashion. But I never argue in that fashion. But your lordship has seen me doing matters in many occasions. I am here, to place my case.
Yes, proceed. Proceed.
But may I come back tomorrow?
No, we will hear you. Don't worry. We are hearing you properly. And we will decide the thing only what occurs to be correct. You please proceed.
Very good.
Yes.
But if your lordship kindly have a look to the writ petition once, but then I'll go to page 95.
Yes.
But the fact remains that my father expired in 92.
Sir, therefore we said we have already decided this issue. We just wanted to see whether it falls in line with that judgment or not.
I have handed over to
you. Have come in with a submission that once three-man committee has decided it is binding. We said, how can it be? We have seen this judgment. We have delivered the judgment. So we are just trying to see whether your client is falling in line with this decision.
That's why I have handed over the judgment to your lordship.
The three-man committee says yes or no, that is a different thing. Yes.
What Mr. Mukherjee was saying, that after that it was sent to the government and government has rejected. Now, on that premise, I interrupt and I said the order of the division.
If we remember correctly, this decision we have decided that the this compassionate appointment is for the benefit of the family. That is the bottom line in this judgment. And the the benefits must reach the family. And therefore, we have decided that it is not, they say that change is not permitted in their scheme. We have held that this is not a change because the appointment has not been granted yet.
Absolutely.
They are only expecting the benefit for the family. You have procrastinated in the matter. You cannot raise this issue that it cannot. This is what we have decided. So are the facts similar? That is all we want to know.
More or less similar. More or less similar.
If it is similar, then, and the other thing is, have they given effect to this judgment?
That Mr. Mukherjee can.
Because otherwise, if it is, we don't know this judgment. Have you given effect to this judgment or not first? Then only we will see whether. Let him find out, because if it is given effect to, then
I'm squarely on this.
If not, then we'll see. Yes, the learned advocate.
Item number 15.
This matter, my lord, would require Mr.
The last occasion, the Honorable Court pleased to direct the Service Commission to file an affidavit disclosing all the materials. Now they have filed an affidavit shockingly without any documentary support. This affidavit is affirmed that all statements are true to my knowledge. And believe those are derived from records. What are those records? Court wanted specifically to get the records. Records are-
Supplementary affidavit in opposition.
And kindly see the affidavit in opposition. If the statements are not supported by the records, how would this statement be believed? The public body. Opposition দিয়েছে তো।
What is the issue? What is the issue?
The issue was, my lord, that petitioner having better academic score, it's an appointment for the post of principal.
Oh, that API issue.
Yes, academic
Performance index.
and then below that the gentleman did not know Bangla, which is one of the requirements. And that's why this court was very kind enough to record. The court has put a specific query to the learned advocate appearing for the commission as to how the API score is taken into consideration while forming an opinion for grant of total marks in the recruitment process. She submits that she will take instructions regarding file a supplementary affidavit dealing with those two submissions. The mere statement by the deputy secretary would not do. Deputy secretary was never in the selection committee. But kindly come to page 2 of the supplementary affidavit, paragraph 3. Voting my lord's order, they say, query number 1, that a selected candidate, respondent number 12, was earlier found deficient in his knowledge of Bengali as per above. Since the recruitment process was founded on an advertisement which contemplated the requirement of fluency in Bengali, the respondent number 12 could not have been selected. Query number 2, and the answer is nothing.
Paragraph 3.
Paragraph 3,
Answer is,
they quote below the
paragraph 4.
queries of the court. Now in paragraph 4, with regard to query number 1, this deponent states that past performance in the interview of any candidate is not considered for assessment in respect of other posts. The interview board comprising of chairman and nominated advisors in presence of the government representative from the higher education department assessed the Bengali knowledge of the respondent. How? In what manner? That was the query. Mere statement would not do. And then further, the fact that the candidate who was not considered by the commission for recommendation against a post in 2007 for lacking in knowledge of Bengali as admitted by the petitioner has been recommended by the commission in 2022. Duly satisfied, his knowledge of Bengali reflects their fair selection. How could they come to satisfaction? There must be some material on record.
So this API was included in the 80 marks. API is part of 80 marks and 20 marks is for the interview. No, his initial case, if we remember, it was that somebody having lower API has emerged successful and he has not. Where have you dealt with that? Where have you dealt with that issue?
But it was not the query that in the last of the your lordship order. There are two queries, that API score, how the API score is calculated, and it is calculated by the higher education department.
You have the order of 31225. Please read paragraph 4.
Constitute in fact the related on number 12 was earlier found deficient knowledge of deficient knowledge of Bengali as per amendments made in paragraph 40 of the original application. Since the regulation chapter which contemplated the requirement of literacy in Bengali, the respondent of not have been selected and the other submitted.
No, we are asking you, you have the order of 31225.
Yes, Lordship. I am reading the order of 312.
Paragraph 4 at second page. Top. Submission advance.
Submission advance is that though was awarded the best API score in the process of assessment, he has emerged unsuccessful and another person having lower API have been selected.
So this was the issue. Therefore, we are asking you, how have you responded to this?
Yes, Lordship. Kindly come to paragraph page 3, paragraph 4. To query number 1, this deponent states that performance in the interview of any candidate is not considered for assessment in respect of other posts.
Oh, that is a different thing. We are asking you regarding this other person having lower API emerging successful. What have you said? That was his whole case. See, Bengali earlier he has been awarded a different marks. How relevant that is, we will see. Whether he is supposed to be static, he can evolve, he can become worse. That is a different thing. But we asked you, we have recorded in the order why somebody who is having a lower API has emerged successful. Either you have to say there is no such fact, or you have to say if the fact is there, how you justify it. That is why we are asking.
That API score is not the parameter to assess a candidate for the subject post. There are lots of things.
So it is one of the many factors included in the 80 marks.
One of the many facts, not the API score is the only parameter. But kindly come to paragraph 3.
Yes.
4.
Yes.
That with regard to practice, this deponent states that API score of the candidate in connection with the post of principal government teacher so-and-so was ascertained by the representative nominated by Higher Education Department on the basis of documents submitted by the candidate themselves. It was decided that consolidated API of minimum 400 points from category 2 and category 3 of API cumulative is required for both posts against respective advertisement. It is further stated that during the interview, for each candidate, 20 marks were allotted on academic background of the candidate and 80 marks were allotted on such performance based on API score and quality of publication, assessment of domain knowledge and teaching skill, and interview performance of the candidate. A final merit list was prepared on the result of overall performance 20 plus 80.
You have given any reply to paragraph 8 of the opposition?
I have not asked for production of records. Records would reveal his affidavit is based on much to my knowledge.
No, we are asking anything you have said about paragraph 8.
Kindly come to me with my reply.
Paragraph 8 of their opposition.
Yes. I state that the API score proves itself that the deponent is academically strong than Dr. Ghosh, as the deponent has highest API score, which is 964, and Dr. Ghosh has API score, which is 569. Moreover, the deponent has got ability to read, write, and speak in Bengali, as is one of the academic subjects is Bengali, and on the contrary, Dr. Ghosh has completed his educational qualification from the state of Bihar, and he had no Bengali subject in his academic qualification. I further state that allotment of marks in favor of the candidate is very much suspicious, as no record has been annexed in the affidavit in opposition, so that it could be understood that the systematic marks allotment was done in favor of the candidates. The percentage of marks does not mean that the total marks is 100 and the candidates have been allotted marks on percentage basis. Therefore, the complicated allotment of marks based on the confidential score must be disclosed for fair selection. This is a categorical assertion, categorical case. And then no affidavit of a state milord can be accepted simply saying that to my knowledge. Unless pleadings are supported by record. Let PSC produce record, but everything will be settled.
Why did you not annex the relevant document showing how it is to be calculated? Why give just a statement?
Specific direction, if the lordship so desire.
No, when an assessment is being done, from where have you gathered this fact that these 80 marks incorporate teaching skills, API, knowledge, domain knowledge, these things? From where do you gather this fact? There must be some procedure that 80 marks are to be broken up or compiled from assessment of these things. So you have not even given any reference. Where is that basis?
That all the API score along with the teaching score, along with the publication, everything is done by higher education department. If state government filed a reply, then state government can produce, and if so.
That 80 marks is allotted by state government.
No, my lord, higher education department. Higher education department is not.
You are assessing authority. You are the. How they can.
Was provided, marks were.
So therefore, they must have sent a requisition. They must have sent you the procedure how the assessment is. Something is troubling this gentleman. Is he having some problem? So they must have told you, given the requisition of number of seats and provided the qualification and how assessment is to be done. So when you say that API is not the sole determinative factor, it is many other, just show it from where you are showing it. That will satisfy.
Lordship made a direction to.
Yes. The
February. Matter will appear 16th February. Correct to that.
Item number 16,
Second was 16, my lord. First option, my lord. Either was that why I have not annexed close all the records relating to an RTI application so made by the petitioner and reply they have forwarded to me. In the said reply, my lord. Finally come to my lord page. Page 60, my lord. But 61. We have talked with my lord, the petitioners, my lord. They have told me, my lord, no such documents was handed over to them. Only this single paper was handed over to them, my lord, by hand, my lord, by taking a signature in their records. My lord, they have been working a lot throughout the year. Most all the days, my lord. And when the office, I mean, running my lord.
Any reply was filed before the tribunal? Was any reply filed before the tribunal? They have filed opposition here.
They are filing opposition here. The paragraph number 8, my lord, in my petition, my lord, I have categorically stated that, my lord, I have been returning back for every working day of the state department, like that.
When we are reading something, you are in the habit of making submissions. You don't want us to read something. The other day also we told you that while we are reading, why do you make submissions? You point out something, we are reading it, and now we are making submission, reading something else. You are relying on which documents? You are relying on which documents?
RT application I have made, my lord. I have also relied you have my an annexure in my lord. Page 66, my lord. Where in my lord, I have also placed along with all other would be employees as a regular employee.
Page 66, 9/11/21 office order. What is the date?
Serial number 24, my lord. My name is
What is the date of the document?
9/11/2021, my lord.
Serial number? '24. Serial number 24. Yes. Any other document?
Yes, sleep also, my lord. Page 65, my lord. I am getting, my lord, the salary and wages for local books, my lord. Yes, sir.
Any other document?
Engagement letter. And thereafter the same was
Page 53.
53, my lord.
Any other document?
The same was time to time, my lord. Extended.
So these three, 53, 65, 66.
And it comes to page 56, my lord.
56 also.
56, my lord. My scale, injection of pay scale, my lord. It was recorded that class allowances as admissible to whole-time government employees. But I am getting, my lord, like that of the government, salaries and wages like that of the government employees. My lord.
Yes. 53, 56, 65 and 66. Anything else? Yes, what kind of system? What is this system? No, that we have seen. There are 3 days in third and fifth week. That we have. No, come to page 56. What kind of order this is? For how, under which provision? Where is the discretion in the authority to make such a page 56? Group D contingent employee. Where, under which provision?
So that they can
So this payment is being made from the contingent fund.
not from the budgetary area.
You have said so in your opposition.
But can you see paragraph 6? My opposition page 3. Petitioner on 9th March 2000 application and informal application for appointment to post of PM considering the paying members LTM with one time basis are not throughout the year to be paid out of the contingent terms of GO dated July 99. Mention here that the state consulting
Is there any enabling provision that you can make, appoint a contingent employee, although he is not serving, although he is not working for 30 days or 31 days in a month, you will pay him a salary, and if required, you will avail his service only for 2 days. Is there any provision? Then how this is being done?
page 54, page 54.
Yes. Oh, so this is it. This is by the finance department. Yes. So he is falling in B. He is falling in B.
It is according to them, but what petitioner has been rendering service on a date.
Right. Whole time, but through, not through. So employment is whole time, but work is not throughout.
There is no advertisement, no selection.
Just see your memorandum 28/7/99. Therefore, we are asking, such discretion is given to these authorities. Do whatever they want.
That's why our decision may instead of authority declared to be
Has to be. How it can be sustained by any statute? They are beneficiaries of such an order. If this person likes someone's face, he will say, come, we are keeping you on a monthly basis. We are keeping you on a monthly basis, but we have work for only 2 days. Wonderful. How can this be done? This has been set aside.
These type of authorization by the Government Department will be declared to other the of the and chief secretary has been directed to not to engage in carry out this time.
Anyway, he is beneficiary of such an order.
Or post is not there.
How can it be? It is a contingent employee. When you came out with such a memorandum, you should have come out with at least a procedure for making this recruitment. Anybody he likes, he will just say, you come and start taking salary per month, but we have work for only 1 day. How can you sustain such? Sir, before that, the first thing is a requirement, assessment of the requirement must precede such engagement. You will pay someone a salary for 12 months and you will take work from him for 20 days in that year. Can it be? There must be an assessment that, look, this is a requirement. We are required to engage someone from outside at least 15 days in a month, 16 days in a month. So let us have someone, instead of having a new face every day, we will have somebody who is acquainted with things. We'll give him 15 days of work in a month. But that must be preceded by a process. Come through the employment exchange, some kind of notice. Nothing is there. It's the government's money, sir. Then these words, how they can be legitimizing such a thing? So you are saying you are not in B.
No, my lord.
You are in A.
Yes, my lord. My lord, kindly come to my page 5, paragraph 8 of my amendment, my lord. Wherein, my lord, I have stated, my lord, categorically that, my lord, the petition has been rendering service throughout the year. That is, in each and every working day of the State Department, like that of the other permanent officials of the State Department, and has been getting pay and allowances as was fixed by the respondent terms of memorandum of such and such. My lord, against the said paragraph, my lord, my respondent authority, my lord.
So in support of such, forget about reply. In support of such averment, you are relying on 53, 56, 65 and 66. Take down. Heard the learned advocate. What are the dates of engagement? Same.
My environment also, they have not denied my letter. In their affidavit in
Where is the engagement? Where is the engagement letter? Page
Page 26.
26.
54. Page 54.
Cannot be 26. 54. 10/3/2000. It is the same. And with the other documents, in this case, same order. (24/9/2019). देखें earlier file. Just give the earlier file. Earlier file.
So, so far last pay scale, in case of B category, they will not entitle for the last pay scale of the petitioner, because they are not getting my letter. That is why I have placed the pay scale, the pay slip also, my lord.
(24/9). So that is also same. Pay slip. There is a pay slip also.
Yes, ma'am.
August pay slip same.
Kindly see, my lord.
But this is of the same petitioner. Oh. Page 65. Where is the pay slip? It is for August. Chamber. Yes. Same. Same. Tribunal's order will differ. OA number and date of order. Well,
Also,
all three.
Item number 19.
Your Lordship, I am for the petitioner on item number 19. I am led by Mr. Subhusai Chatterjee. I am praying for not today as he is engaged in another court, Your Lordship.
Every issue is decided by some case or the other. No, but there is no repeated adjournment. Oh. Yes, by way of last indulgence, we are adjourning the matter for the
এটা কি কালকে থাকবে?
list on Monday. Give the date. Give the date.
Nine. ওনার নামটা কি? কি হলো?
Item number 20.
This is my application. Lordship may remember on last occasion, Lordship has.
Don't depend on our memory.
Lordship has had this matter extensively. This is regarding a constable who has been accused of rape and subsequently he has been terminated from his service. And later on, he was acquitted by the High Court, Lordship. And his dismissal followed by his conviction only.
So what is the provision? Please show us which rule will apply, whether there is an application to be made post acquittal or it is upon them to take cognizance and to restore you. There is any requirement to submit a joining after acquittal, or any point of time the person can come and say that give me all the benefits.
Lordship, admittedly, he has not joined after acquittal, Lordship.
We didn't ask you that. We are saying, is there any provision that casts an obligation on the state that once you are acquittal, they should take steps?
Lordship, had it been a case,
Is there any provision which says after your acquittal in a criminal case, you have to go and join their duties? What is the provision? Let us see. We know the facts, we remember now that he was dismissed based on conviction. Much later, his conviction was set aside in appeal. Though his conviction was set aside in appeal, he never came to the authorities. After his retirement, he is coming and saying, give me all the dues. So therefore, let us see whether you are required to intimate regarding acquittal, whether you are required to submit your joining, or everything is to be done by the state. If that is the situation, then you will
submission is that, Lordship, had it been the case that a disciplinary
come to the provisions. You make your submissions after we see the.
I'm just saying, Lordship, that regarding the disciplinary proceeding, they have taken the point that there was a disciplinary proceeding, so I have to, that has been set aside first. But on that ground, Lordship, the learned tribunal.
Did we ask you that?
But learned tribunal has dismissed.
Therefore, we are asking you. Though if that point is wrong, we will relegate it for what purpose? We want to be satisfied. We'll decide once and for all. So therefore, we are telling you, there was no proceeding.
There was no proceeding.
It was a dismissal based on the conviction. So there was no independent inquiry. Now, when the substratum is gone, you are entitled to relief. Substantially, this is your case. But the fact remains admitted that you never went to the authorities after acquittal. Now, what is the effect? Let us see what is the rule. It requires you to intimate them regarding acquittal, or it is obligatory on the part of the state to take steps, or there is a joining required. It is under which provision? Police Act or CCS rules?
Lordship, regarding detrimental benefit, Lordship, DCRB rule will apply.
The same will apply. No, but regarding the disciplinary proceeding and the effect of acquittal, that will be governed by the procedure. It is under CCS or Police Act?
It is Police Act.
Which provision? Therefore, we are asking you, please show us.
Lordship, earlier perhaps, Lordship.
Last day also we asked you the same.
Lordship, they have.
There may be a situation that the rule specifies that the authority which has relied upon the conviction that should review the matter periodically. What is where is the procedure?
Lordship, right now, Lordship, I don't have the DCRB rules, but on earlier occasion, Lordship.
We are not asking for the DCRB rules. We have the DCRB rules. We are asking you what is the effect of acquittal.
Lordship, effect of acquittal, Lordship, may I please show one judgment?
No, you may not. That judgment is rendered under that rule which has been considered. We are asking you what is the procedure in your Police Act. Why can't you show the provision?
Lordship, there is no specific provision regarding that. If there is a provision of dismissal after charge sheet and regarding everything, whatever the procedure they will follow, that is there. But in my case, Lordship, no procedure of disciplinary proceeding. There is no disciplinary proceeding at all, Lordship, because no charge sheet was there, no hearing was there. It has only followed by the conviction, Lordship. When the conviction is not there, Lordship, I have been acquitted. So that, Lordship, my submission is that the ipso facto that the disciplinary.
Very well. So you don't want to rely on any rule. Yes, very well.
Mr. Day is appearing for state due to some health issues. He is not present today. I am praying for an adjournment.
All right. Tomorrow he will come?
Yes.
Not today. You ask you A, you say B. You are repeatedly saying the same thing. We want to see what is the provision. You are not assisting us with reference to the provision. You are repeating the same submission 20 times over 2 days. Keep saying that. Very well. You go through the provision, it may be to your benefit. It may not also, but let us see the provision.
Item number 21.
Not today.
Lord, I appear for the petitioner. Would your lordship take it up next? Feeling well.
Very well. As prayed by senior advocate, the matter is adjourned. Go and rest.
Actually, my lord, my junior said I will not be able to. You have to. I said okay. And you cannot stay at home. Also.
No, that we always accommodate when there is a.
I know, but because of the weather will not change. This is happening.
Yes, weather here is so pleasant.
No, here it's okay. I was in Port Blair, but before that Ranchi.
Ranchi would have been slightly colder.
And wait.
Item number 22.
Mr. Sen, can you please, we are not in this case, that in the other case he was referring to proceedings under some police act. What is the name of the act? It's a local act.
One is that matter the Police Act, but I do not know matter what act matter referred there to.
Police regulation of Calcutta.
Calcutta Police Regulation.
And there is one regulation for the remaining Bengal also.
No, Police Regulation Calcutta.
Oh yes, there is one for Bengal and one for Calcutta. All right, we'll see. It's good business. मंडे वीकेंड में दे दें इसको कब रखे हैं उसको कब रखें आइटम 20 हाँ 19 हाँ वीकेंड में दे देना हाँ
My lord, please to direct me to deposit the original application which I filed before the learned tribunal and the replies also. But I am filing.
You have copies.
Copy of the application. My lord was kind enough to direct this my lord to furnish the copy because of the fact that actually my lord what the petitioners my lord what they claim therein and their averment therein because their main contention is that initially there was draft charge sheet and they did not my lord they objected to that draft charge sheet but despite being that inquiry proceeding continued and the disciplinary authority also, my lord, on the basis of the inquiring authority, my lord, took steps and immediately they filed that, my lord, the OA application therein and challenging the same that on the basis of draft charge sheet, how they can be proceeded with. Now, again, thereafter, my lord, after that order passed, then my lord, that order was passed that the on the basis of the submission made on behalf of the authority that it has become infectious, so no order. But subsequently, the authority again, my lord, served or slapped upon the charge sheet, and inquiry proceeding again started, concluded, but the again way filed and said that how it can be proceeded with when the earlier order there was no leave granted to continue the same. At this juncture, my lord was kind enough that to go through this original way when they filed before this proceeding.
Well, in the reply, your lordship would kindly find that they have stated that after, my lord, after issuing a charge sheet, the draft charge sheet, they again, my lord, issued a memorandum correcting the draft charge sheet, and they held an inquiry on that basis, and they withdraw, and they prayed before the court for withdrawing those two.
It started from paragraph 6.10 with regard to their averments and their contention regarding that. Six point 10, 6.11, 6.14. Lord, there is one matter fixed at 2 p.m. Would your lordship be kind enough, my lord, that my lord, today, my lord, in view of my lord, there is a my lord, the one of our colleagues' mother, Mr. Supriyo Chattopadhyay's mother, expired today. Now, my lord, I have to go to the my lord, the committee.
Tomorrow? Well, day after tomorrow. Huh? Tomorrow I have some difficulty, but day after.
As jointly strong.
Item number 3.
On application.
Filing something. You are filing something.
Compliance report, my lord. Earlier occasion, my lord. Direction. No, my lord, 40 application and my lord 40 orders. All are my lord annexed. Yes, sir. Sir. Only my lord, page number 15.
15.
15. A compliance report, my lord. Lord, page number 17, only my lord disputed regarding the 40. 39 already complied with, my lord 41 is pending, and my lord we have complied with, my lord serial number 40. Kindly have a look this. Horihor Dealers Private Limited, so and so, 6 kata, 35 square feet, so and so, dag number, so and so, my lord. All are
Yes. So this is your complaints.
yes, my lord. I have mentioned also, my lord, paragraph number 90 onwards, my lord, in my compliance report. Lord, previous, my lord, 6, my lord, page number 6 and my lord 18. Kindly have a look. This above 80, my lord, we have already clarified.
Yes, the same thing you have stated
Yes,
in
yes.
Yes, you have got a copy of this.
Just now, my lord.
Then all 40 have been mutated, then what remains?
The list is whether
a Karkhana factory on the date of listing was in operation or not. If it is in operation in 15th April 1955, all property vested to state, except in the ceiling. The question arose before your lordship, when the study for the BLR of the your lordship court, whether the Karkhana was in operation on the date of listing. Number 2. On 15th April 55, whether the Karkhana was in operation or not. If it is in operation, one way of looking. If it is not in operation, on that day, then my lord, no question of vesting comes in. Your lordship's court head, I should say, altering the order of the learned head, that Karkhana is in non-operation, and that's why this is besides this. Karkhana is not in operation. The factory is not in operation. That's why it cannot be vested. If this is clear, my lord, then where you are mutating on the basis of the lordship's order, whether you can keep that description of the property intact,
Keep that.
that description of the land as Karkhana, and the West Bengal Land Reform Manual clearly says there are two ways of mutation. One is by inheritance, other by deed. When you are mutating the name on the basis of the deed, you have to adhere to the description in the deed itself. Deed specifically said what is the quantum of land, what he has done. According to their own whim, they have done it without considering the deed. Whether this can be said that is in compliance.
No, what according to you, what is the discrepancy?
Discrepancy and the quantum of land is less, not in commensurate with my deed. And the land reform manual clearly suggests how a mutation could be made.
No, it has been recorded as Karkhana. And it should be?
It should not be Karkhana.
Then what it should be?
Vastu. The record of it says.
So where in the judgment does it say that it is Vastu land? Where in the judgment it says it has to be recorded as Vastu land? No. So therefore.
Other if the Karkhana was not closed.
Oh, all right, that you have already submitted.
Answering your lordship.
Yes.
If the Karkhana is not closed, then your lordship judgment could not be there. This should not be thrown out. Basic criteria for this judgment passed by the division bench is Karkhana is not there. Up to Supreme Court. Then kindly consider if after when they mutating my name, if still it is said it is Karkhana, whether it is Karkhana compliance. I'm asking the question. I know this is contempt is going to before that, but I have a right to assist my.
No, where again we are asking you, anywhere in the judgment does it say that it's to be mutated as a Vastu land? No.
It is not said. But at the same time, it said you mutate.
Yes, that is said that.
If today mutation is made,
we have not even seen the judgment yet. Where is the judgment? Because we were made to understand 40 mutation applications were to be allowed. So that you have submitted in terms of the judgment, you say as per the judgment, it is to be recorded as Vastu. So where in the judgment does it say? Let us see. So therefore, those are issues which that you can always, that can be, there is a remedy for that. So therefore, can we now expand the judgments? Then therefore show from the judgment, let us come to the judgment, from where in the judgment you say that this is a, please come to the judgment. Okay, 58. 58 of? 58 of what?
Factor or orderless are disputed. For a business to come to the owner of plot of land, then it will certain about that. Certain that the structure and is named in the record of right. Upon the date of the paid order, is widow and the son transfer and convert the said land in favor of the Indian Middle Trustee Private Limited. Subsequently, the record of right was corrected, and the land comprised under the same deed of sale was referred to Calcutta instead of Bangladesh. This is a mistake. What are the mistakes about money?
Got it. Notice mark some.
On judgment, I have marked all the relevant. I do not here the copy of the judgment. Huh? So to have to go. If it is there. Oh, this is the.
আমি পাঠাবো ঠাকুরকে পাঠাবো এটা কোথায় যাবে বই বই বই
Yes, you want to show something.
Yes. Like it comes to the first page of the judgment.
No, first let us see what is the mutation order. Where does it say? Where does it say Karkhana?
Is the record of right?
Where is that?
I don't know. I don't know.
Then how do you know it says Karkhana?
I know. That's why it's counted as right.
How do you know from where you are saying this fact?
From my can you see this?
No, from the record. Where? Show it from the record. Show it from the record.
That has not been arranged. But now that online showing change.
by affidavit, your lordship.
This is the record.
Thereafter they come. Alice compliance. So it is not there. Now,
So from this record, they have submitted. From where are you saying this? That has been recorded as.
now that's not fine.
Where does it say Karkhana?
Page 41. Page 41 can you come?
Page 19.
41.
At the bottom, bottom 730 Karkhana.
This is your dealers private limited. This is it has been recorded. The name of the riot is your dealers private limited. 90. Name of the riot is your dealers private limited, and nature of the plot is Karkhana.
And where is your application? Where is your application for this?
My application for correction.
Yes. No, your application for this.
Mutation. My application for mutation.
That's at page 98. 99 is the record which says Karkhana for the 40th application, page 99. The 40th application, and 98 is the application for mutation. There is no such thing. Sir, please come to page 98 of today's affidavit that they have filed.
Let me check. Page 98.
Not served.
Just now.
So it is served.
Just now, sir.
But it, therefore, you
Yes.
was open to you to ask for a time, but you have not.
I said I don't target you. But can you see the proof of application for mutation?
Come to page 98 of that affidavit.
98, I am 98.
Yes. It doesn't say anything. See, that is the record of rights as it existed. In that record of rights, only name has changed. No, we are not going to go into the merits of the issue. In the contempt, sorry.
For the purpose of recording the name, you have to adhere to this.
That's not the point. Point is you have made an application.
Yes.
That application is page 98.
Application is.
Yes.
This application is trust you Rule 56 of the Honorable Land Law Manual.
But then they have allowed the application.
What allowed? Everything
Come
else.
to any other application, earlier application.
Nothing. Kindly once read.
See, you made two submissions. Your two submissions are that one, it should have been entered or described as Bastu in the record of rights.
It cannot be Karkhana.
No, you said Bastu, sir. I don't even know the term. I knew only when you said.
I say it, now it is Bastu.
Yes.
But I say your Lordship court order said it cannot be Karkhana because there is a winding up petition. Winding up petition presupposes Karkhana is not there.
What is the date of winding up petition?
Yes, my lord, can you see the record?
What is the date of winding up order? Prior to 55. The winding up is prior to 55.
55.
So therefore, the judgment is very clear. The status of the land as on the date of vesting. The judgment says so in so many words. So therefore, that subsequent development, how it can be reflected? Therefore, we asked you, the winding up is prior to 55 or post 55?
Judgment cannot be prior to 55.
Sir, the winding up is prior to 55 or post 55?
Cannot be prior to 55.
So therefore,
Repeat. It is my fault, but I could not be confident to my. 1955 is the crucial date.
yes,
On that date, whether the Karkhana was in operation or not is a signing word.
yes.
If it is in operation,
Not operation, whether there was any structure thereupon or not. That is the relevant.
no. Karkhana, sorry, but I should not go to Karkhana has to be in operation.
Just now we have seen the order, therefore we are saying. And those issues are not here.
I am not asking for it doesn't agitated and decided.
Decide. Yes.
Karkhana at the division bench was not in operation. That's why it was not allowed to be placed. This fact is subject to correction when it is clear. If it is a Karkhana is not in
Where is this? Just read this finding from the court's order. That because Karkhana is not operation, therefore it could not be. Just show that finding. Which paragraph?
It may not be so many words.
So therefore, we are asking you show that from the judgment that because Karkhana is not in operation, therefore there is no.
That's a law.
Sir, please show from the judgment. You said it is decided by the court. Where is it?
Any judgment, my lord,
Is that there anywhere in the order?
starting from free finance up to even
All that has been considered. Louis finance has also been considered. Where the court found that the Karkhana was not in operation, therefore it did not exist. There is no such finding.
It is obvious.
You are saying that is the finding, but we don't find such finding.
Finding always not in.
All right.
The law is this that
Very well.
if the Karkhana is in operation, it should be vested.
Sir, we are not hearing the writ petition again. The judgment has to be complied in letter and spirit.
Right.
The judgment says that.
That's the case here. You have to adhere to the law of the land on that date. Your orders were directed to
So therefore, first submission was land should be recorded as Vastu. Second submission,
don't
we have recorded from your submission.
I am wrong.
All right. So we are crossing it.
It cannot be
Yes.
Karkhana.
Cannot be Karkhana.
Karkhana. Why I am saying this? Because under the land reform manual, it is a duty of the authority to inspect and correct. And two types of mutation.
So ROR was not corrected.
Not correct.
All.
The law by law is well aware that two types of mutation is there. One is by inheritance.
So where is the direction for correcting the ROR in the judgment? Let us see. Where is the where is the judgment?
Yes.
Where in the judgment it says ROR has to be corrected?
It is not necessary. The statute itself says.
So therefore, we are here for compliance. At the outset, we said we are here only for compliance.
Now, the division by judgment. From the last page, last slide, basically.
Yes.
The Justice Tandon's judgment, division by judgment says, in view of discussion made above, the tribunal is hereby set aside. The application filed by the tribunal stands allowed. What is mean there? That is, my lord, your lordship can come to page 93.
No. It is in view of the discussion above it is allowed. So what is the discussion above? The discussion above is that it is non-agricultural land. That is all. Karkhana, no Karkhana, functioning, not functioning, Vastu, not Vastu, those are issues of record of rights.
I have to add it. The one term is non-agricultural land.
Yes.
Non-agricultural land within that campus.
Because if it had been agricultural, it would have come within the mischief of stealing. Therefore, it does not come within the mischief of stealing.
This non-agricultural tendency, non-agricultural land, within this campus, there are different type of land survey. Hart, Bajar, Karkhana, all are coming. There are different types of land coming under the campus of non-agricultural land. If it is non-agricultural land, it cannot be wasted. Here in this particular case, it was shown that one of the nature of the land is Karkhana. Suppose in a given case, we not have this. This is the Karkhana land in a Hart, Bajar. These are main case.
In fact, Mr. We have not found Karkhana also used anywhere.
Well, ask like this,
Neither
why
Vastu nor Karkhana.
why did I come to the best
Neither expression Vastu nor expression Karkhana has been used in legend. It is agriculture, non-agriculture only.
Again, my lord, there is a little difference. Agriculture and horticulture is not.
That's all. They are not saying.
Within this campus, there are certain different types of lands are there.
All right.
One of these is Karkhana. These may be hard, bayar, these are certain types of land. This starting with this judgment is therefore after a winding up petition was filed. Well, our winding up petition for withdrawal of the Karkhana. So Calcutta is not there. That's why winding up petition, and from the winding petition, court says with my client purchases. So it cannot be said that after the passing of the winding up and the sale, Calcutta is still in existence.
All right.
Am I clear to you?
So therefore, in this contempt, we should direct him to change the record of rights.
No, I will not ask for this. What I will ask for, my lord, comply with rule 56 to 56 to 75 of the original land code.
So therefore, are we expected to do that in contempt? That is the first issue.
Because of the fact, otherwise this is not a compliance at all.
All right.
The act, why not is well out of those line of judgment, whether it's stupid, data and spirit has to be compliant. Just I will cite it at the end. So here, my lord, if your lordship once look to, I am asking your lordship to do this by your lordship court. Your lordship find what is the application for petition, how the entry in the mineral register, what is to be looked into. Here, my lord, transfer is on the basis of my sale deed. And in court sale, winding up petition, can you keep it
So therefore, what you are saying is that after winding up, there was no Karkhana. If there is no Karkhana, why they are showing Karkhana? So instead of Karkhana, they should show what? They should show what according to you? Both of you are arguing or you are arguing? Both of you are arguing or you are arguing? What is this? Continuously you are disturbing. Excitement is antithesis of professionalism. Yes.
I am submitting, brother.
Yes.
The court proceeded on the basis, what are the admitted facts? My client.
We have. Therefore, we are asking you. We are trying to summarize what
Yes,
you want. After with winding up, there is no Karkhana. There is no scope for entering it as Karkhana. So it should be entered as what?
As two things. As this is a mutation on the basis of my sale deed.
As what? Yes.
On the basis of the sale deed. Two options are open under 56. Either to look into my description in the deed, by which mutation is paid for, what is the nomenclature and the description of the land, or a physical inspection by the authority under the land record. There cannot be, so far my knowledge, there is no third option. And why I am saying this, madam, I once look through section 50 of the West Bengal Land Laws.
Section
50 of the West Bengal Land.
Yes.
Oh, about Bhumuli. This is by section 50 by the time of right. What the time can you say it? I will not say.
Yes.
And for time it's still
Hey, book from the land. Ask for the book. Get it from the land. No, we have I have never seen these matters here. Few cases with Justice, His Lordship Justice Tandon I have seen. Otherwise, in this roster, that tribunal is not before this.
No, that's why the books are not. We are very basic.
Yes.
Section 15 is maintenance of record of right. Sad. Maintain up to date in the prescribed manner the village record of right by incorporating the changes on account of two options. Mutation of names as a result of transfer or inheritance. Here it is on the basis of transfer. Am I clear to my lord?
Yes.
What recorded that I have purchased from the.
You are clear. You have said it is based on a deed. The deed was executed pursuant to a winding up proceeding. Therefore,
100%. I am clear. Now, my lord, I take that. What is to be done? Kindly come to F.
this is the procedure for mutation.
No, this is one of maintenance of record of it.
Ah.
And
Therefore,
so can you look to it?
Yes.
Then can you? Such other causes as necessitated a change in the record of right. And can you consider whether in view of the winding up petition and the purchase thereof and application for mutation on the basis of the conveyance, whether this change is necessitated under subsection F or not.
50F.
50F. 51F. This subsection what? F. Because it says that two things are there. One is by transfer or inheritance. Inheritance you are not concerned here by transfer. If it is by transfer, then there should be changes. Such other causes. What are the causes here?
Execution of a deed.
No. Nature of deeds.
Huh?
My deed says this is a.
So therefore, the deed is the cause.
Deed is
because your deed says so, it is a cause under F.
F. And I am not saying this is sacrosanct. Again, I don't. It is not in my sacrosanct.
That is the only development you are showing, nothing else.
Showing, but
Yes.
they will not only look into the debt. If they desire, they can also physically inspect the property and come to it.
That you said.
That has not been done.
That it can be by inspection or by inheritance. So therefore, once the deed says, they were required to take all the action.
And that is on their discretion, whether they will rely fully on the deed or they can give it. Suppose something is written there which is not correct. If it is said Vastu, but in reality it becomes Han, they can mutate the name by changing San.
Yes.
Now, once can you look to this? The full chapter is there. My lord, Justice again, finally, probably there is no book can take term to see Rule 56. The landing of
Rule?
The full chapter is there. How is to be maintained?
Not true.
Landing from Bengal, didn't it? Then
Where the act? This is act.
not act. Oh, okay,
All libraries get it from
not regularly now taking land.
that. But
Sometimes against justice business in a full chapter is there how to be maintained, how to be maintained.
Manual আছে
Chapter is there.
this is a manual or it is a rule?
It is the name is land record manual. This is the first step you are looking. Power. Your Lordship court never said that without adhering to this procedure, you viewed it. And what is the place in the court which has been allowed? To mutate the petitioners in the record of right. Okay, once they try to see page 93 of the content of petition. That has been done. Page 93. See which the page 93. This is the petition before the tribunal which has been allowed by your lordship. So now my lord can consider test my submission whether only your lordship got directed to mutate my name on the record of right. On the basis of my application for transfer the contents reader there, whether they can divorce such application and statute.
Yes.
This is the question whether your lordship got directed to my lord has seen that prayer my lord page 90 for my satisfaction I want to do which my lord the court has allowed. The record in the name of petitioners in the record of right will be correct. So record of right correction is section 50 as shown to your lordship. Where can be corrected? Either by inheritance or by transfer. And if at the process of transfer, it requires certain change.
What is the prayer A? Just read prayer A.
Prayer A.
Page 93. Page
Yes.
93.
Issue a mandate directly the responsible authority to record the name of the petitioner in the record of right.
All.
Section 50 says change of record of right. Under which eventualities? One is transfer.
So therefore, under 50F, they should have changed the.
50A, this is by way of transfer. So all the ingredients mentioned in this transfer deed has to be adhered to, coupled with rule 56 to 70. Well, if that is not done, because it can state this is compliance. This is the procedure I have relied on the judgment of the Clearance Court. One line is after development, that's what I said. Can you come to page 3? In later and
This is a repeated sufficient number of times.
at least one or the put on record.
Yes.
These are some circles of my service. And if it is not done, then I have to start de novo from DLR.
For what?
For the correction of this.
Yes. That's all. Anything else?
No.
Yes. Who is appearing? Mr. Dar is
I can straight go to that extent that even today I can respect and add up to 56 to 70 percent.
My lord, kindly come to section 4C1 of Land Reforms Act 1955.
Please, yes.
Please, yes, means I will get rid of it.
We never intend to get rid of any council.
Don't take it
We are here to deal with you all day.
Don't take it always serious.
Yes. The senior council, if you want to excuse, then we are extending courtesy by saying please, not by asking you to leave.
My lord is not, I am not regularly before my lord, just extra service.
Yes.
So, my lord, before I go to 4C, kindly come to section 4 capital B, maintenance and preservation of land.
Section 4B.
4B, capital 4B.
B as in Bombay.
Yes, B for Bombay. Maintenance and preservation of land. One is every Rayat holding any land shall maintain and preserve such land in such manner that its area is not diminished or its character, the second part, or its character is not changed.
Four capital.
I'm sorry. I'm sorry. For capital B.
Not for subsection B.
No. Well, I'm sorry.
Yes. Every Rayat.
Every Rayat holding any land shall maintain and preserve such land in such manner that its area is not diminished or its character is not changed or the land is not converted for any purpose other than the purpose for which it was settled or previously held except with the previous order in writing of the collector under section 4C. So there is an embargo on a Rayat not to change the nature and character of the land without prior approval from the appropriate authority. And there is a duty fixed up by the statute upon the Rayat to how to maintain the land as it was settled originally. Now, let kindly come to 4C. If Rayat wants to change it for the purpose, original purpose, when it was settled.
Yes.
Now, let kindly come to 4 capital C. Permission for change of area, character or use of land. A Rayat holding any land may apply to the collector for change of area of character of such land or for conversion of the same for any purpose other than the purpose for which it was settled, I emphasize there, Malad, for which it was settled or was being previously used or for alteration in the mode of use of such land. So Mr. Basu's client never applied for conversion, never applied for change in the record of rights. Change is as the new Rayat has come in the place of the previous transferor. So that change deals with the mutation, only name change, either by way of inheritance or by way of transfer. That change does not speak about the change in the character or classification.
Yes.
Now, my lord, kindly take the pen of the chapter 7, that maintenance of the record of rights, what Mr. Basu was submitting, that section 50, then he never placed section 50A, 51A, and 51BB. Now, my lord, kindly come to section 50B. 50 capital B, modification of record of rights.
Yes.
If a block means the entire block of under any BLLRO is up for draft publication and then subsequent the objection was filed and that objection was considered and finally published, record of rights has been published. Nobody has come forward to change the classification. Hang on, the classification is wrong. It's not properly done. Nobody has come forward. That stage is over. Now, I'll kindly come to, I'll be placing 50B, then I'll be placing the other sections of this chapter. There is a procedure to do that.
Yes.
Now, my lord, 50B, modification of record of rights. The state government may, in any case where it so think fit, make an order by notification published in the official gazette directing that the record of rights in respect of a district or part of a district as maintained up to date under section 50 be modified by eliminating from such record the entries, if any, which have been deleted and scored out under that section from time to time. This is not the case. Now, my lord, kindly come to the section 51, revision or preparation of the record of rights. The state government may, in any case, if it so thinks fit, make an order directing that the record of rights in respect of any district or part of a district be revised or prepared by a revenue officer in accordance with the provisions of this chapter, and such rules as may be made by the state government in this behalf. Then two, a notification in the official gazette of an order under subsection shall be conclusive evidence that the order has been duly made. Now, my lord, kindly come to the very important section, that is 51A, draft and final publication of the record of rights. When a record of rights has been revised or prepared, the revenue officer shall publish the draft of the record so revised or prepared in the prescribed manner and for the prescribed period, and shall receive and consider any objections which may be made during such period to any entry therein or to any omission therefrom. So draft publication, authority goes, inspects the land, inspects the moja, then put up a draft list, and that draft list, in seeing the draft list, if anybody X has a problem, Mr. X has a problem.
Therefore, substance, what you are submitting is, if a record of right is to be corrected, there is a procedure is specified in which natural justice is inherent. All that has never been done. Nobody has invoked this. Therefore, there is no scope.
So he has to follow the section 4C, that is a different proceedings for change of classification, not change in the record of rights. Means he is trying to confuse my lord by saying that change in record of rights in two aspects. One is name change, that is mutation, that is under section 50. And one is change of classification of land, that is under section 4C, which Mr. Basu's client has never filed, or before the stage of 51A, which I have read just now, I have placed, that is draft and final publication of the record of rights. That was one of the stages. The classification could have been corrected, but during that time nobody has come forward. That stage is over. Now the next stage is, if Rayat wants to come in, then he would be applying for application under section 4C, not in the mutation application. Whatever form has been filled up by Mr. Basu's client, all are mutation form. My lord,
Yes, we have seen that. We have seen one at page 98. We have seen that.
That's right, my lord. Yes, all the pro forma has been filled up for the form of mutation. Now there is another form for change in classification that has not been filled up by Mr. Basu's client. Now he wants to make this contempt proceedings.
And where is the procedure for mutation, in which provision?
That is under section 50. That change he wants to, well, he placed that
Section
change 50. Yes, 50 is only for mutation. Maintenance of the record of rights, well, 51AA. Mutation of names as a result of transfer or inheritance. Two change. One is section 4C, that is area and that is classification, nature and classification of the land. And another one is section 50 deals with the area, name, transferee's name, Rayat's name, and their share, respective share, and what would be the revenue. All of this, new settlements of land, variation of revenue, alteration in the mode of cultivation, All of this been dealt with under section 50. Not change in the classification. Change is mentioned in under section 4C. And there is a different rule to implement section 4C. Not in the garb of mutation. And there is also a fee. So there is also a fee, prescribed fee to be paid to the government. One is for mutation, another one is for change in classification. There is a fee. Let them show that they have deposited that fee for conversion. There is nothing. No, my lord. What was there, my lord? I have in my affidavits, my lord, I have mentioned the paragraphs in the writ petition. What was the cause of action? They came before the LRTT. And then subsequently they went up to before my lords, before High Court.
LRT prayer is there at page 93, we have seen.
Yes. Only consider the representation which they have made, that is for mutation, not for change in the classification. If my lord, kindly have a look to the paragraph 14 and 124 of the writ petition and para 16 and 17 of the writ petition, my lord, will find that they have sought for mutation before the revenue authority. That was not done. For the inaction on the part of the inaction of the revenue authority to not considering their mutation application, they have come before the LRT.
So far as the pleading is concerned, they are bound by whatever has been said before the tribunal, because that is what was being considered before the writ court. That cannot be changed.
Now they come and says, oh, hang on, the change in the classification has also to be recorded.
So
this is absolutely different cause of action.
The deed which has been executed as a result of the winding up proceedings, does it describe the land otherwise?
Even if I take it, even it describes otherwise. This is the obligation on the part of the Rayat to go and apply. Kindly come once again to section 4C. It starts with saying that Rayat has to apply before the authority. It's not the obligation on the after the final publication is done. A Rayat holding any land may apply to the collector for change of area of character of such land or for conversion of the same for any purpose other than the purpose for which it was settled or was being previously used, or for alteration in the mode of use of such land. This is the statute says that this is the obligation on the part of the Rayat. Rayat comes forward with an application, pays the fee as per the pro forma, like mutation form. There is also a pro forma for change in classification. He pays the fee, then revenue authority entertains that conversion application. This is absolutely a different cause of action. And there is nothing on board to show that there is already an application under section 4C is pending before the authority. They won't be able to show it.
Yes.
No, no, this should be my submission, my lord. The contempt proceedings is, the scope is very limited. Now,
What
Mr.
it has
Basu,
been, how it has been described in the deed.
my lord, I do not have, and since I am appearing online, I do not have the writ petition here. If
You are appearing without brief.
no, my lord, I have the briefs, or my lord, not the writ petition, my lord.
Because they have also not shown that in the deed there is anything like that.
Well,
Just-
deed is annexed in the, if I'm not wrong, deed is annexed with the writ petition, not in the contempt petition.
Does the judgment anywhere say the nature of the land?
No, no, the
As per
judgment
the
says, as my lord rightly pointed out to Mr. Basu wanted to say on the date of vesting, it was not in operation as factory. That sort of a finding is not there. This judgment only deals with,
That
with
finding is
this.
impossible because it has gone in winding up much thereafter.
Yes.
That finding cannot be. There's not a
Only
possible.
non-agricultural land. That's why 6.3 is not applicable. Hence, my lord has directed that their representation may be considered. The tribunal's order was set aside.
A single deed has been annexed. Very good, Chiru. Yes, you have not pointed out anywhere from any deed.
Specifically say that what is being sold is vacant.
Where does it say Bastu land?
It does not say Bastu land.
All right, all right, all right.
But vacant land can't have a
All
factor.
right, all right. Yes.
And it also says that the price is
All right.
is also the considering the character and condition of the land.
All right. So there's nothing to indicate what is the nature of it, other than the fact that it is vacant, which it has to. That's all.
They were right.
Well,
The party. This for all.
And over to is their book.
I'm deeply obliged.
Yes.
With your lordship's leave, may I?
Books period.
Fine. What other thing?
Item number 214.
So, four orders.
Yes.
Just can read the concluding part. The provisions of the ROPA rules contemplated grant of higher scale for acquisition of higher qualification in the relevant subject. In the present case, Masters of Library Science, full stop. Section 14 therefore does not in any way operate against the 1990 ROPA rules insofar as grant of higher scale in recognition of acquisition of higher degree is concerned. The Land State Council has not been able to point out any provision in the Act or understood which can be read or understood to impose a bar on grant of higher scale in recognition of higher qualification under the ROPA rules. Section 16 also reads, then we have quoted section 16 that whatever has the terms and conditions will not change under the 2005.
Disadvantage.
The act is therefore provides the terms conditions of service shall not be varied to the petitioner's disadvantage. The prevalent terms and conditions prior to coming into force of the 2005 Act therefore cannot be varied to the disadvantage of the teaching or non-teaching staff of any school. Find no reason to interfere with the directions issued by the Honorable Single Judge in the order dated so and so. However, since in view of the fact the appeal is being disposed of now, we consider it necessary to observe that the time limit of 8 weeks specified by the Honorable Single Judge is modified to be read as starting from the date of receipt stroke production of a copy of this order. Like there are some very small mistakes, we'll be correcting that.
Much obliged.
No, I always try to keep patience, but I don't like repetitions.
Yes. If you have seen my just now.
Yes.
Everything is learning lesson for us. So what is learning just is to be learned. Everyone, council and advocate. Then of the court first part. Get much of it. May I? Oh, correction.
There are few here and there. It will be uploaded to
Item number 23.
Yes. The earlier occasion, my lord, has directed me to submit a report.
You have served a copy.
Yes, my lord, I have served.
You want to see it? You want to go through, you want an opportunity to go through it, or you want to proceed? Yes, report
Not next Tuesday. Tuesday week.
Yes. Any difficulty?
No.
Item number 24.
Petition being led by Mr. Siddhartha Banerjee, ma'am.
Chukriyo.
The respondents are not here, my lord.
So this is good for you? There is something, they had to file something or there?
No, my lord. On the last occasion, as per your lordship's direction, they have complied with the order, my lord, and the petitioner has rejoined the post in the original posting, my lord. Now the main hearing is to be done.
An arrears is cleared.
Lordship, the area part is not yet cleared off. From 11th of December 2024 to the 28th of February 2025, that part they have still they have not paid off. I'm being led by Mr. Well, that part they have not yet cleared.
Anyway, so let us see. Let us proceed. This is that Group D employee
Lordship,
who was transferred,
Lordship, the Group D
ignoring that circular which acknowledges the inconvenience of Group D employees. That was the case.
Lordship. He was transferred from Dhonekali in Hooghly district to Darjeeling.
Who was appearing in this case? For state? Who is appearing for state? Mr. Sen.
Amal Sen. Mr. Amal Sen.
Amal Sen. Opposition and everything is filed. Where is that policy?
Page 85, my lord. Lordship, kindly.
And another thing is this Group D employees, they have a district cadre or there is a combined centralized cadre for throughout the state?
Centralized cadre, my lord.
From where can we find this?
That.
My experience in the past has been that normally these Group D employees, they have a district cadre. Within the district, they can be transferred from one office to the other.
Then, my lord, I need to take instruction.
Because see, this guideline, obviously they will take the stand that the apex court has repeatedly said these guidelines are only to be observed, keeping in background the administrative exigencies if required, the court cannot impose. This will be the sum and substance of their stand, resisting a transfer. So the first thing to be known is why such a rule was framed or policy taken. Most probably, we are just thinking out loud, we don't know. Recognizing the fact that they are having a district cadre, it says that the transfer should be done to a place of posting from his usual place of residence. If it is a state cadre, such a provision would never be taken in a guideline. So if he is a district cadre person, then the perception will change. If he is a state cadre, then perception will differ. So tell us what it is.
Lordship, may I take?
Sorry, Lordship, it's a state cadre.
It is.
Possibly.
Group D.
I'll take instruction. It's not that district cadre cannot be moved beyond the district,
But my lord, so far as Group D are concerned, my lord, these regulations, my lord, this memoranda were issued only to ensure that they are not moved far away, because my lord, they draw a very, my lord, minimal salary. And my lord, if two families are required to be run, my lord, one at his native place and one as a transfer place, my lord, it will not be financially feasible for them, my lord, to run.
Can be transferred from one Singapore Anyway, you please answer that
My lord, I need
query
to take
with
instruction.
reference to some rule.
Wait.
Where is the cadre composition of Group D staff that must be there in some
And
service?
if it is district cadre, my lord, my case would be on a higher pedestal.
So we are saying the perception will change. Otherwise, they will take they have nothing else to say than to say that it is a transfer. Court should refrain its
Normal
yes,
grievances will
and even if there is a policy,
But
there
my lord,
no
simply-
right is vested in the person.
Okay.
That is what they will say.
But my lord, simply nowadays, my lord, the rule has, my lord, subject to again correction by lordship, a little changed by my lord, the Honorable Apex Court. Now the Honorable Apex Court is saying that, my lord, merely by saying that administrative exigencies were there, well, that don't help them. They have to show, my lord, what administrative exigency was there, because of, my lord, why, my lord, the post fell vacant, who got transferred from which place to another, why was that my lord, post required to be filled up by this particular gentleman. These things are, my lord,
That is there, but those issues are looked into once the court takes a view that it will exercise jurisdiction.
Yes.
Otherwise, in every case, the court cannot embark on an inquiry as to why this transfer was done, who are the persons and where they have all gone. That will not be done. So therefore, we have to see the composition of the cadre
My lord,
and
that I
then
will check. My lord, I'll check and come back.
the
Item number 25.
Item 25, my lord, IFA for the petitioner. My lord, this matter also resignation of a doctor. My lord, your lordship may know, my lord, that
resignation.
doctors, my lord, lord's long
Over.
pending issue. No, my lord, till date I have received nothing.
In regard to this order, which lordship has already passed on 13th of January 2022. Type of that order, lordship has passed necessary directions. The department has already considered the resignation that the team order can be passed on lordship. Because all these matters have been taken administrator was appealing.
It's in relation to another matter.
You are with the government pleader. Where is he? In all the matters, he has given us the order of
My lord, in
accept.
one matter, my lord, I have just handed over a copy. Your lordship passed an order after the government pleader produced a instruction from the authorities that by this resignation will be accepted. It will take more than 3 or 4 months to get the
Vigilance, clearance, and interviews.
So your lordship has confined them to four
Four-
weeks of time. my
4
lord.
weeks or 8 weeks? 4 weeks.
So that order I have just handed over to her. The same order is
So
there.
where is the order of acceptance?
Lordship, then I have to come back, lordship. I'll inform the learned.
Talk to them. Come tomorrow. Yes, not today. Unnecessarily, you are keeping the. You can't force someone to work if somebody doesn't want to work. Not claiming anything. He wants resignation, simplister. He's not casting any burden on you. No pension, no nothing. How can you force him to work?
Twenty-six.
I appear on behalf of the petitioner. The husband of the petitioner Milan, he was an upper division clerk of the Public Works Directorate, Tomluk.
Now died on 26th of April 2021.
2020?
26th April 2021. Now, my lord, the left wife being the petitioner, one son, one daughter, and aged mother. Now, my lord, a representation was made on 7th of June 2021. This was made praying for compassionate appointment having regard to the distressed condition of the family due to the economic ruination and starvation. That my lords will be pleased to find at page 33. Now, an affidavit was affirmed by the legal heirs indicating that they have no objection if the mother is given compassionate appointment. Now, first time I approached the learned State Administrative Tribunal. Now, my lord, praying for grant of compassionate appointment. Now, it appears, my lord, that the order which was passed, which is the subject matter of challenge, that I will be placing before my lords, that your lordships will be pleased to find that order from page 40 to 56. I'm sorry, my lord, I stand wrong. This my lords will be pleased to find.
Page 60.
No, my lord, not 60. 60 is a very important document which was born, and where, my lord, your lordships will be pleased to find that the Joint Secretary to the Government of West Bengal, he writes a letter to the superintending engineer indicating that the date of birth of the applicant is 24/1/1978, and the age of the applicant at the time of the deceased employee was 43 years, 3 months, and the applicant belongs to general category. Therefore, condonation of excess in age was not recommended to and my lord, it appears, my lord, that he has relied upon certain circulars, which my lords will be pleased to find at paragraph 4 of this order.
This page 60 is a communication of 28/10/22.
Yes.
Does it deal with an application for relaxation of maximum age
But I
criteria?
am grateful to my lord. I say I found it that there is a provision for relaxation, but I will be placing that, and I am grateful to my lord. Now, my lord, your lordship, as I was indicating to my lord, my lord, that the order which was passed by the learned tribunal just 1 second, my lord. My lord, that my lord will be pleased to find from the last annexure, 19th of June 2025. The learned tribunal, my lord, observed last annexure.
Besides, she had not applied for condonation there.
Now, I am grateful to my lord, and my lord, I would be submitting that in the affidavit in reply, the opposition had been filed
where, my lord, I find that the documents which have been annexed in the writ petition, those are replica of the documents, my lord, which was dealt with while filing the opposition. Now, in the affidavit in reply in the first paragraph, I have indicated that there is a reference of 1, 2, 3, 4, 5, 6 orders, which in the speaking order, your lordships have taken note of that.
2810 order.
Yes. Now, two things I would be only indicating to lordships that the government of West Bengal Labour Department, as my lord was indicating in a notification, my lord, it is at page 9 of my affidavit in reply, 3/12/2013. This is the notification. Now, there, my
251
lord,
251 EMP.
I am, your lordship, I do not have that much of experience, my lord. Before I say, your lordship is indicating that. Absolutely, my lord, I bow down to my lords.
Yes.
Now, my lord, therein in the note at page 15, there is a provision, condonation of excess in age in case of eligible cases will be made by the respective head of the department or their subordinate officer who are competent to make the compassionate appointment as per existing provision. Now, I have further, my lord, taken the pains to ascertain as to whether there is any particular rule which prevails in the field that West Bengal Services Group D recruitment rules of 2009. This was enacted on 5th of May 2009. You know, kindly take the pains, my lord, before it starts from page 34. The relevant provision is at page 36, where there is an indication that the age of the Miller, this is for age limit for general appointment, not for Miller compassionate appointment, is an exception to the general rule of appointment. Now, Miller, your lordship may kindly take note of the fact that the age of the candidate shall not be less than 18 years and more than 40 years on the first day of January of the date of publication of the advertisement, provided that the upper age limit shall be relaxed by 5 years by the candidates belonging to categories of scheduled caste, scheduled tribe, West Bengal, scheduled tribes of West Bengal, and by 3 years for the candidates belonging to other categories of OBC. Provided further that the upper age limit shall be 45 years for persons with physical disabilities specified under any law for the time being in force. Then what your lordship was indicating, power to relax has been indicated in para 9, power to relax in page 36.
চোদ্দ নম্বর জাস্ট এটা লাল মারা এটা দেখতে পারতেন Six or five, activity in reply.
And the exercise of discretion for condonation of age by invoking the power of relaxation, why it was not done, it is not known to the petitioner.
No, but there is whether there is any specific application for relaxing the
By the pin. Milad,
obviously that is why if you see 26 EMP
yes,
clause 14 BB,
26 CMP.
yes, you have it.
No, I don't.
That is the 16. That is the 2016 policy on compassionate appointment. It is amending various provisions of the earlier.
That is towards page 109 of the writ petition.
Come to 10 BB then. Come to 10 double B. Ten double B, last page. At the top, in the box at the top. Revised, you see the revised provision. Why you have not done this? You have got it. You have got that.
This particular
Page
26 EMP.
Page 111 of what is this? The writ petition.
Yes, that is with me.
10 double B. See the revised provision, what it says at the top.
10 double B. Yes. Your Lordship is referring to the first paragraph.
Yes.
The concerned authority in the department or office should meet the members of the family of the deceased government servant immediately after his death to advise and assist them in getting appointment on compassionate ground. The applicant should be called in person at the very first stage and should be advised in person about the requirement and formalities to be completed by him. A record of such meetings should be kept with the office of the conferring authority and appointing authority. All cases of compassionate appointment should be disposed of by the administrator, preferably within 6 months of the date of receipt. An undisposed of case where the date or incapacitation has occurred prior to the issue of this order, but after the issue of this order number 30 EMP dated 2/4/2008, could be looked into afresh if it complies with the revised instruction.
So 10 BB, they are obliged to go and inform you about these things. Your husband was working on which post?
He was working as upper division clerk of the public works, the road directorate, Tomluk Highway Division.
So why have you not considered the excess age condonation?
Lordship, may I say? Lordship, the regulation for compassionate appointment, Your Lordship, is subject to the general rules of eligibility of age, Your Lordship.
That's why we are saying, that is why we are saying consider relaxation. We are not saying that it does not apply. See, he is referring to that rules. That is for general appointment. That gives the power of to the governor to exempt the rules application wherever considered necessary. His application is not to be considered that stringently. His application, the condonation is to be considered under the scheme by the authority who is competent to appoint. That need not travel to the governor.
No, Your Lordship.
So therefore, you should have examined it.
Your Lordship,
It says the office the competent authority in the office or the person making the appointment. So it could have been considered then and there.
this candidature had been considered, Your Lordship.
Yes, but then you have not considered whether she is eligible for relaxation or not. What is the family profile? Have you got the family profile?
In this case, Your Lordship, the employee had left behind his wife, Oloka Nayak, a 20 years old adult, Your Lordship, Shanti Nayak, and a minor, Shonwai Nayak, your lordship.
So
In this
20-year-old must be married. Therefore, she has not applied.
No, your lordship. Living with the family, your lordship. Unmarried, your lordship. This is there, page 19 of the opposition, your lordship. Since there was another member already eligible for the post.
Where have you said these things?
Your lordship, may some
You have not said anything.
application of the petitioner, your lordship, page
Page 18 of your opposition.
opposition, your lordship. This is the application. The relevant statement is at page 19. The condonation or the of excess of age is not to be applied in a straitjacket formula and under the rules for all the cases, your lordship, but for exceptional cases, your lordship. And in this case, your lordship, the profile, the application, I shall indicate in
Condonation provision is there in 251.
I shall indicate.
251 EMP. That is the note that he was placing, yes.
Clause 6C, 6 note A. This is merely a note. The condonation of excess. May I read, your lordship?
Yes, eligible. What do you mean eligible cases? Please define.
I shall indicate, your lordship. The condonation of excess in age in case of eligible cases.
Eligible cases. What is eligible case?
Eligible cases will be made by the respective head of the department or their subordinate officers.
Yes.
Who are competent to make the compassionate appointment as
So
per
this
existing provisions, your lordship.
So therefore, what is the existing provision regarding relaxation? That is what we are asking.
Existing provisions for relaxation, your lordship, it has been annexed by the petitioner at page 112 from 112. Relevant portion at page 113. It provided further that the upper age limit shall be 45 for the person with physical disabilities specified under the law.
We are asking you.
The
What is,
relaxation shall be considered according to this age limit, your lordship, where that can be extended till 45 in case of disability. Physical
no, that is not a relaxation. That is provided. That is the limit. That is not a relaxation. Don't make such submissions.
Second paragraph, I shall read.
Please,
Provided
just don't say anything. Please, yes.
I shall read the entire thing. The age of the candidate not be less than 18 years or more than 40 years of
Yes.
provided the upper age limit shall be relaxable by 5 years for the candidate belonging to categories of scheduled castes and scheduled tribes of West Bengal, and by 3 years for the candidates belonging to categories of other backward classes and of West Bengal. Provided further that the upper age limit shall be 45 for the persons of physically disabled.
So this is not relaxation. This is not relaxation.
Proviso is relaxation, your lordship, and the third proviso is also a relaxation. Provided also that the upper age limit shall be relaxable for the ex-servicemen.
These are not relaxations, madam. This is a rule to be observed by the recruiting bodies,
yes, your lordship,
which says that this is the limit for such and such. The power to relax is on the next page. That is the only power. At clause 9, these are not relaxation. This is the general limit for PWD, for SC, ST, and OBC.
A particular limit.
Correct. So beyond that, it will not be done.
Nothing in this rule shall be construed to limit or abridge the power of the governor to dispense with or relax recruitment of any of these rules for such extent and subject or conditions such as
here it says
that is for the governor to relax. For the power of the governor to dispense with or relax the recruitment of any of these rules To such extent,
That is a different provision. Please read it first before you place it. That is for the governor to exempt application of the rules in appropriate recruitment, because these are recruitment rules.
but is my respectful
Here in your, you come to the note what it says.
Yes, Your Lordship.
It is to be granted by
Department or other
subordinate officer who are
who are
competent.
to
Then
make compassionate
this
amendment.
does not have to go to the governor.
Yes, Your Lordship, but as
So
per the
what is
existing provision,
for eligible cases? What is an eligible case?
eligible case would be, Your Lordship, the other qualifications of
No, madam, it appears to be otherwise. Prima facie, it appears to be an eligible case will be such whose financial stringency is found by the three-man committee, and he is otherwise found to be entitled to grant of this benefit, and if there is something lacking in the family otherwise. Here there is only one daughter, and the son is a minor.
son is minor and unmarried daughter who is also
Yes.
eligible to apply.
So whether in the circumstance she is, but you have never considered the condonation. You only say she has not applied for condonation. That's all.
Yes, Your Lordship, there was no application for condonation in any way, any event, Your Lordship. This condonation of excess has to be considered in accordance at par with the existing provisions, Your Lordship, which would be the regulation for the age group. Applicable for all regulation.
If this reason is not sustainable. Yes. In case of eligible case. Eligible means other category. He has to be granted. There is no any guidelines supplementing this 2013-251 EMP. What do you mean by eligible
Your
case?
Lordship, it has been recorded in the order, Your Lordship. The order challenged, Your Lordship, that in relaxation, we have the authority has considered the point clause of relaxation, Your Lordship, as well. Paragraph 4, and it has specifically recorded that since the applicant did not fall under the clause proviso, second proviso of the relaxation rules, age limit, there then she belongs to the general category. Such relaxation cannot be awarded to her.
If she falls in that, where's the question of relaxation?
Your Lordship,
Only if she doesn't fall in that limit, then only an issue of relaxation will arise. Your consideration is a one-line cryptic consideration, the last sentence of paragraph 5. You read the last sentence of paragraph 5.
belongs to the general category. Combination of excess in age was not
Not recommended only because only suitable candidates are offered appointment. What is this? Only suitable candidates. So why she is not eligible under this note?
Your Lordship, may I read this from paragraph 4, Your Lordship? The proviso laid down in serial number 7 of memo such and such read with amendment of 2016 of Finance Department of West Bengal, Service Group D Post Recruitment Rules 2009 such. The age of the candidate shall not be less than 18 years and after amendment more than 40 years. Provided that the upper age limit shall be relaxable by 5 years for the candidates belonging to the categories of the scheduled caste and scheduled tribe of the West Bengal, and by 3 years for the candidates belonging to the categories of other backward class. In the instant case, death in direct harness of the government employee such and such is 26th April 2021, date of birth of such and such. So the age of the applicant at the time of the decease is 43 years 3 months. The applicant Alka Nayak belongs to this category. Such confirmation of age was not recommended to ensure that only suitable candidates are offered appointment, Your Lordship. Lordship, the applicants of a general category and the rules indicate
It is there. So that is minimum age between 6 months. 6 months. 6 months. This, which is between 16. Earlier page.
That was deleted.
Yes, right. Right. It says in eligible. This is means eligible under 6 itself. So 6, what is the eligibility? Eligibility is contained in 6. Here. Eligibility.
Those are the conditions.
So where is the eligibility for compassionate appointment? It says in eligible case, if otherwise eligible, then it can be considered.
Should the eligibility is clause eligibility Lordship clause 6 on
Correct. Now, yes.
Lordship
6A, 1 and 2.
yes, Your Lordship.
So has anyone examined that?
That the entire application were examined, Your Lordship.
So where have you said that on this ground she has been found ineligible?
Your Lordship, the order itself says that he has been found ineligible only on the ground that
Maximum age.
limit.
So therefore this aspect has not been considered.
Your Lordship, the eligibility consideration, Your Lordship, they kindly may I read the note once again. Condonation of excess in age in case of eligible cases will be made by the respective head such and such to make the compassionate appointment as per existing provisions, Your Lordship. This existing provision has ought to be read with the eligibility age limit criteria as mentioned under the West Bengal Services Group D Post Recruitment Rules 2009. Your Lordship, where the proviso clearly indicates on which cases, in which cases the age limit can be relaxed, the upper age limit.
Read the scope and object of that rule.
In exercise of the convert for provision such and such, the governor is pleased to hereby make following rules regulating recruitment to different categories of Group D post in Secretariat, Directorate and other offices under the rule-making power of the government of West Bengal.
Correct. So this is that the rule making power can, in appropriate case, the governor can say, of course, the minimum age criteria is 18. Now that is in note C of 6. A is containing the maximum,
Family in
note C.
second of the appointment should be eligible.
Now that you have deleted in 2016. So that is contrary to 2009 or not contrary to 2009? It is not governed. These are in exception to the rule. Therefore, it says ineligible cases means eligibility as per clause 6. So did anyone examine that they are eligible or ineligible under clause 6? Only if they have examined and found that she is ineligible, then they can say will not consider. If she is eligible, then 10 BB, they were required to go and tell her that you, instead of your place, you asked her to be appointed. Something like that. You can't just mechanically reject an application like this. There has to be some consideration. We are not saying that ultimately she will succeed.
Your Lordship, all these steps and all the inquiry have been conducted.
Where is the 3-man inquiry? Where have you stated in which document that as per 6, the income does not fall below 90% of gross monthly income, or that the pension is of such and such amount that is she is not entitled?
May I submit this, Your Lordship? In the event of the candidate is ineligible on other grounds, Your Lordship, the question of relaxation of upper age limit does not arise. Your Lordship, the relaxation of upper age limit arises only in a case where at
Ineligible case, ineligible case.
ineligible cases. But that eligibility and that consideration has to be at par with the existing provisions of age limit, Your
What are
Lordship.
you submitting?
Which is the,
You're saying that this, how are you blowing hot and cold at the same time? Please think out your submission before you say something. How is it possible? What you are submitting, is it acceptable by any standard?
Your Lordship, the age
You are
limit
saying
is-
hot and cold at the same time.
Your Lordship, admittedly the age
So you're
limit-
saying eligibility is the age criteria and that has to be satisfied. Then what is there to relax? Then nothing is there to relax.
Your Lordship, may I submit this? The upper age limit is 40. Admittedly,
Make
the
some
upper age limit is 40.
conscionable submission. Don't just submit. like-
Regulation clearly indicates that the relaxation may be done in two cases.
Not sustainable by any standard. What you are submitting is not sustainable by common logic. Cannot be. That relaxation will be within the scope or within the minimum and maximum age. Then where is the question of relaxation?
Your Lordship, the
Relaxation will only be after.
Your Lordship of 2009, where it clearly indicates that the it can be the upper age limit can be relaxed only in case of 5 years in case of a particular category of.
And what does the rule say about minimum age criteria relaxation?
Minimum age criteria.
Please show. What does it say? If it is so sacrosanct a rule, let us see what it says.
Your Lordship, page 113, Your Lordship.
Yes.
The age of the candidate shall not be less than 18 years.
So
and more than 40 on the first day of January.
is there any provision for relaxing the minimum age criteria?
No, Your Lordship, but there is an age of relaxation of the upper age limit.
So therefore that means minimum age cannot be relaxed.
No.
Anyone who is not 18 years, he cannot be appointed.
He cannot.
Why you have deleted 6C then in 2016? Come to the 226 EMP. You have deleted 6C.
Yes, Your Lordship.
Earlier it said he had to be 18 years on the date of death. Now you don't say so. You say up to 5 years he can make an application. So
No,
if he
Your Lordship.
becomes eligible, even after 5 years, you are going to consider him.
No, Your Lordship. May I
You
read?
have deleted 6. First read, then submit.
Yes, Your Lordship.
Please read the 2016
I shall read.
26 CMP. What does it say about 6C?
Your Lordship, may I? 6C.
Deleted.
6C.
Now what is 6C? Read 6C.
Your Lordship, 6C is deleted.
Then
6C says applicant for compassionate appointment should be eligible and suitable for the post of in all respect under the provisions of the relevant recruitment rules, which include 6A subclauses and 6B as well.
no, read 6C, note C.
See, I'm reading, Your Lordship.
Yes.
Applicant for compassionate appointment should be eligible and suitable for the post in all respect under the provisions of the relevant recruitment.
That is not what has been deleted. 6C within brackets small c has been deleted.
And
The
6C,
dependent, ma'am.
that is the dependent.
Yes, that has been deleted.
Then the minimum age of recruitment within 6 months. That is minimum age of
So that is relaxed.
within 6 months, because Your Lordship, this other two extended timelines had been introduced, Your Lordship. That is of 2 years, within
By-
the age of 2 years.
By the governor.
Your Lordship, in this regulation, Your Lordship.
No, in this EMP issued by you.
The 26 EMP.
Yes.
There has been a relaxation regarding 2 years where
Yes.
attaining the minimum age of
So that can be
within
done contrary to the rules.
and Your Lordship, that is from the date of the
That can not only be done contrary to the rule, that can be done contrary to the Contract Act also.
Your Lordship, here may I submit this, Your Lordship, the relaxation, here the regulation has been changed, Your Lordship, to in 2016, not relaxing the lower age limit of appointment.
It has.
Here the regulation says that the applicant can apply on attaining the age of minimum.
Correct. So even if he is not eligible.
2 years from the death of.
Correct. So even if he is not eligible on the date of appointment, he can apply.
No, he's not. He ought to be eligible from the date of appointment.
No.
Yes,
Oh,
Your Lordship, I shall
please.
Your Lordship,
You are
10A.
making submissions which are not founded. Please don't make such submissions.
Can I read this? Your
You
Lordship,
may read it 100 times. You will not come to that conclusion. What you are saying. You may read it 100 times. You will still not come to that conclusion.
Can I read this?
Yes.
In 10AA, last line. The dependent member must invariably attain the minimum age of appointment at the time of consideration.
Therefore, at the time of death, it is not required.
No, at
That's
the
precisely what we are saying.
Your Lordship, at the time of consideration of the application of the applicant, she was overaged, Your Lordship.
That's enough. We have understood. You are not able to make out any case.
Your Lordship, it has to
Sorry.
be consideration with
We
the
have allowed you
relaxation
sufficient.
given in the rules of 2009, Your Lordship.
There is nothing.
Your Lordship,
There is no consideration. There is no consideration.
The order, it has been specifically recorded, Your Lordship, that the relaxation is only in case of 5 years and 2 years.
It's a cryptic order, madam. Nothing has been done. Just one line you say it can't be.
The order once.
You have already placed it 10 times. How many? That's enough. That's enough. Heard the learned advocate for the party.